Yes, my lord.
Who is
Bola
there?
Audu Innocent is online, man.
Can I see your face? Can I see your face?
Okay.
Yes,
Yes, my lord. Bola Audu Innocent is online.
Use your audio, use your video.
Okay. Okay, I'm trying to turn it on now.
Okay, the claimant.
I am here, man.
The claimant present. Any other person in court? Is any of the defendants online?
yes, my lord.
Please, who is here, please? The first, second, or third?
First defendant.
Represented by who?
Joshua Apebo, Secretary General.
Very well. Any other appearance? How about the second and third? Is the second and third defendant online? Is any of the... Are they online, second and third?
No,
Alade Bashir, Mr. Tony Etimokon.
No, my lord.
Okay, thank you. Appearances.
With the greatest respect, my lord.
Go ahead.
My name is Babatunde Adeosi. My humble appearance is for the claimant. I'm grateful.
Any other appearance? Please mute yourself, Learning Counsel. Any other appearance? Any other appearance for the defendant? Neil. Mr. Joshua Akbebo, your counsel is not in court.
Because it was impromptu, so it's not aware. So
okay, he's aware. He's aware. I gave a directive to the registrar of the court, and the registrar of the court had actually passed the message across to him. So he's aware. Well, in any case, you are in court, the judgment is ready, and I'll go ahead to deliver same.
As it speaks, my lord.
Very well. Please mute yourself. Mute yourself. Everyone should mute yourself. Please mute yourself. I don't want to hear any news. I mean, any noise on the ground. Mute yourself. Mute your phone. So here is the judgment of the court. This action was commenced by a general form of complaint filed on the 13th of July 2022, wherein claimant praised the court for the following. 1, a declaration that the claimant is the lawful substantive national president of the first defendant. 2, an order of the Honorable Court mandating the first defendant and all its organs to unconditionally reinstate the claimant back to his elected position as national president of the first defendant with immediate effect. 3, an order of the Honorable Court mandating the first defendant, its agents, and privies to ensure that the claimant serve out his elected tenure of 4 years without any interruption. 4, a declaration that the emergency meeting of the CWC requisitioned by the second defendant and held in Lagos on the 9th of March 2021, which purportedly reached a decision that the claimant should step aside and appointed the third defendant as the acting president to replace the claimant is irregular, unlawful, illegal, void and ultra-vires its powers, and in contravention of the constitution of the first defendant. 5, a declaration that the purported resolution passed by the CWC for the appointment or selection of the third defendant as acting president is irregular, unlawful, illegal, void and ultra-vires its powers, and in contravention of the constitution of the first defendant. 6, a declaration that the claimant did not violate the constitution of the first defendant, nor has been found guilty of any criminal charge by NAPTIP to warrant the purported decision taken by the first defendant, CWC. 7, a declaration that the incident, deliberations, and decisions of the emergency NEC meeting held on the 16th of March 2021, which sought to affirm the decision of CWC of the 9th of March 2021, asking the claimant to step aside from his office as national president of the first defendant, is irregular, unlawful, illegal, unlawful, void, or travails its powers in contravention of the constitution of the first defendant and in contravention of the order of the Honorable Court for parties to maintain status quo. 8, a declaration that the incidents, deliberations, and decisions of the emergency NEC meeting held on Monday, the 16th of August 2021 and Tuesday, 17th of August 2021, respectively, which sought to expel the claimant from membership of the first defendant, is irregular, unlawful, illegal, void, and or travails its powers in contravention of the constitution of the first defendant of the order of the Honorable Court for parties to maintain status quo. 9, a declaration that the first defendant has retired from the civil service and no longer a member of the first defendant. 10, a declaration that by the continued stay in office of the third defendant is unlawful, contrary to public policy, equity, and the constitution of the first defendant. 11, an order of the Honorable Court directing the third defendant to vacate the office of the national president of the first defendant with immediate effect. 12, an injunction restraining the defendants, agents, privies, representatives from interfering with the lawful business of the claimant as the national president of the first defendant. And 13, the sum of 3 million naira only being the cost incurred by the claimant for bringing of this suit against the defendants. Please mute yourself. I don't want to hear any news at the background, please. The case of the claimant is that he was arrested and detained by the National Agency for Prohibition of Trafficking in Persons, that is NAPTIP. And while in detention, the second defendant requisitioned an emergency meeting of the first defendant Central Working Committee, which is also known as CWC, where it was resolved that he step aside as the president pending the resolution of all criminal-related issues brought against him by NAPTIP, and appointed the third defendant as the acting president, and that the resolution is irregular, unlawful, illegal, void, and ultra-vires its powers, and in contravention of the constitution of the first defendant. According to him, he approached the court to enforce his fundamental human rights, and the court made an order that parties should maintain status quo, that in flagrant disregard and disobedience to the order of court, the National Executive Council of the first defendant eventually removed him as president illegally. He was subsequently expelled from membership of the first defendant illegally, hence the suit. The defendants, in response, filed their joint statement of defense, which was amended, wherein they admitted that the claimant was the national president of the first defendant, but was suspended and subsequently expelled from the association. That the second defendant duly retired from service, having attained retirement age, but was thereafter appointed on contract for 1 year, 3 months by the neck of the first defendant in accordance with the constitution of the condition of service. They further averred that after the CWC of the first defendant examined the issue of arrest and detention of the claimant, he was asked to step aside as president for the third defendant to act as president. They also averred that the defendants did not act unlawfully in every step taken to suspend the claimant and subsequently expelled him, and that same being an internal affairs, the court has no jurisdiction to look into it. They maintained that this action ought to be dismissed. Claimant opened his case by calling one Solomon Onakinon, who testified as CW1. He adopted his sworn deposition. He was cross-examined by Learned Defense Counsel, and a document which was admitted and marked as Exhibit S was tendered through him. One Loretta Chiem Amarachi equally testified as CW by adopting her written statement on oath and her oral evidence, and was subsequently cross-examined by the defense counsel. One comrade, Abba Hassan, testified as CW3 by adopting his written statement on oath. He was equally cross-examined by the defendants, and documents admitted and marked as Exhibit Abba was tendered through him. Claimant testified as CW4 by adopting his sworn deposition as his oral evidence, and documents admitted and marked as Exhibit B1 to B20 were tendered through him in his examination in chief. Was also cross-examined by learned defense counsel, who tendered Exhibit B21 to B24 through him. The defendants, on their part, opened their case by calling one comrade, Boboy Balaka Igama, who testified as DW1. He also adopted his sworn deposition. He was subsequently cross-examined by the claimant counsel. The second defendant testified as DW2. He equally adopted his sworn deposition as his evidence in this case. Documents admitted and marked as Exhibits L4 to 7 were tendered through him by the defendants. He was later cross-examined by the claimant counsel, while document marked as Exhibit L8 was tendered through him by the claimant. After an in-depth and a careful consideration of the processes filed in this case, the submission of learned counsel to both parties and the authorities cited in support of their respective arguments. It is in the light of all this that I frame these issues for the determination of the suit. One, whether this suit is clothed with jurisdiction to entertain, whether this court is clothed with jurisdiction to entertain claimant's case. Two, whether the claimant can amend its processes as he sought to do it in the motion filed on the 12th of April, 2024. And three, whether the claimant has proven his claims to be entitled to the relief sought. With regards to issue one, it is the contention of learned counsel for the defendant that claimant did not comply with the provision of Rule 40, paragraphs A and B of the first defendant's constitution, which is a condition precedent to the institution of this action. According to him, the rule provides a precondition that a claimant as a member of the union must first comply with before approaching the court, and that failure to comply with the said precondition ought to ask the jurisdiction of this court. He cited in support the cases of Haladu and Access Bank, Atolagbe Awumi, Oyewumi, Governor of Ekiti State, Governor of Imo State, and Amazi. Learned claimant counsel on his own part submitted that the court has the requisite jurisdiction to entertain and determine the issues submitted by claimant for determination in this suit. He stressed that the technical objection raised by the defendants are misconceived, reiterating that the days of technicalities are long gone, embracing the current vogue of doing substantial justice to both parties, in that cases are heard and determined on merit. Cited in support of his assertion the case of Bello and Attorney General of your state, the case of Fawahimi and Akilu, citation provided. It is a position of claimant's counsel that from the issues formulated, learned defense counsel obviously failed to appreciate the case of the claimant by coming to conclusion that this action is intra-union dispute, that it was the defendants who precipitated the crisis in the first defendant when it purported to remove the claimant from his position as national president in an unlawful manner, but that it must be noted that claimant initiated this suit after the defendants had allegedly expelled him, thereby shutting him out and disconnecting him from every right and obligation which accrued to him as a member of the first defendant, which according to him includes the right to explore internal mechanism for dispute resolution, which is prescribed by Rule 40 of the first defendant's constitution. Maintaining that Rule 40 does not apply to the claimant in the instant suit because claimant's case is unlawful interference with his lawful mandate, leading to his unlawful removal without recourse to the provisions of the same constitution by members of the first defendant is a violation of the constitution of the first defendant that cannot give rise to Rule 40. He cited the case of Amazike and Registrar General CAC and another. He further submitted that by subscribing to the jurisdiction of the first defendant under Rule 40, claimant will have acquiesced on his right, and by implication validated the action of the members of the first defendant, thereby allowing the defendants to be judges in their own cause. He cited in support of this the case of CFAS, Nigeria Limited and Phoenix Capital Limited and another, and Section 15 of the National Industrial Court Act 2006. He maintained that claimant, having been denied of his membership rights, cannot be expected to explore Rule 40 of the First Defendant's Constitution at the time this suit was instituted. He ordered the court to discountenance as well as dismiss the objection raised by the defense counsel on the basis that claimant has failed to activate the said Rule 40. In addressing the above preliminary but germane issue, I must first say that the importance of jurisdiction in the life of the suit cannot be overemphasized. This is because it is the foundation and the blood that runs through the veins of an action without which a case cannot thrive. Excuse me, please. Please, if you are online, if you are in this courtroom, please mute yourself. Thus, a court must be shown to have the vials to entertain and adjudicate on the matter. By the Logos Classicals case on this subject, which is the case of Madrikola and Ikem Delim citation provided, it was held that in order for a court to have jurisdiction to entertain an action, all these ingredients must be present. A, the court must be properly constituted as regards numbers and qualification of members of the bench, and no member is disqualified for one reason or another. B, the subject matter of the case is within jurisdiction of the court, and there is no feature in the case that prevents the court from exercising its jurisdiction. And C, the case comes before the court initiated by the process of the law and upon fulfillment of any condition precedent in the exercise of jurisdiction. See also the case of COP Anambra State and another, and AA Omahai International Limited, the case of Indul and Wayo and others, the case of Petro Jessica Enterprises Limited and another versus Leventis Technical Company Limited citation provided. Needful to state that all these preconditions must be present, and the absence of any of them would deprive the court of the competence to entertain a suit. See Ashaka versus Ngwachuku, Network Securities Limited and Dahiru, NCC versus Motorphone Limited. However, there is a clear distinction between jurisdictional incompetence, which is evident on the face of the proceedings based on the provisions of an enabling statute, and one which is dependent on ascertainment of facts and claims of the claimant. Jurisdictional matters are categorized into two for the purpose of waiver, and these are substantive jurisdiction and procedural jurisdiction. None of the parties have power to waive the former, and same cannot be conferred on court by acquiescence, while the latter can be waived in law. There is no doubt that any condition to the filing of an action has a flavor of jurisdiction, but matters of procedural steps such as this fall under procedural jurisdiction, which must be raised timeously in order to be heard. See Fashade and Babatola. This is because a defendant who submits to the jurisdiction of a court or tribunal in spite of a defect in jurisdiction procedurally cannot, because of waiver, complain later. See Hebe and Zachary, Indayako and Dani Toro. The defendants in this case did not at the earliest opportunity raise the issue of non-compliance with the condition precedent in Rule 40 of the First Defendant's Condition till when trial has commenced and claimant has almost concluded his case. In other words, the defendants raised this issue after they have in fact submitted to the jurisdiction of this court. This said, it is however expedient at this stage to consider the stipulation of the said Rule 40 of the First Defendant Condition as to exploiting an internal mechanism before an action in court may be instituted by a member to see if failure of the claimant to comply with same will affect the jurisdiction of this court. It is clear from the said rule that the organs of the first defendant that shall consider the report made by an aggrieved member with a view to using internal mechanism to resolve an intra-union dispute in the first defendant is the CWC and the NEC. The claimant's grounds in this case, and which is the subject of this action, is the action of the CWC, that is the Central Working Committee, suspending him from his position as the president of the union, and the subsequent act of the NEC, permanently removing him from office as president of the union, and appointment of another person in its place and also his expulsion from the union by the neck of the first defendant. As such, the organs who are in the center of the claimant's contention or grounds in this case are the ones who will consider the report in Rule 40 of the first defendant's constitution. Section 30, subsection 1 of the 1999 Constitution as amended encompasses the twin pillars of justice, namely A, audio authorum partem, that is here the other party, and B, nemo judes in causa sua, do not be a judge in your own cause. As such, it is a standing principle of our jurisprudence. No one can be a judge in his own cause, expressed nemo judes in causa sua. To expect that claimant ought to have complied with Rule 40 of the first defendant, in which case his report of a dispute hearing will have to be considered by CWC and NEC. Excuse me, please mute yourself. Mute yourself. Mute yourself, please. To expect that claimant ought to have complied with Rule 40 of the first defendant, in which case his report of a dispute hearing will have to be considered by CWC and the NEC, whose actions brought about the dispute in the first place, will be a negation of some of the very well-known principles or tenets upon which our common law is founded. Of great and utmost concern is that such will be a total derogation of one of the major pillars of the principles of natural justice, where it is not allowed for one to be a judge in his own cause. See the case of Federal University of Agri-Makurdi and others versus Adaikponu, the case of Agbabiaka and the First Bank of Nigeria PLC, the case of Silva and Independent National Electoral Commission. In my humble view, complying with the provision of Rule 40 will have been a breach of claimant's right to fair hearing. This court is a court of both common law and equity by the provisions of Section 13 of the National Industrial Court Act 2006, hereinafter referred to as NICA. It is a notorious maxim of equity that equity follows the law. See the case of Obo and Another versus Nigeria Football League Limited and others, the case of Akilu and Fawahimi number 2. In this instance, both common law and equity will not sanction the doing of an act that is in breach or will be in breach of a right to fair hearing. The scenario in this case can be likened to a situation where an Igwe, Oba, or an Emir has grounds or issues against the kingmakers for suspending and expelling him, and the chieftaincy rule requires that he reports to them. How lawful will this be? The implication of this is that the Igwe, Oba, or Emir, as the case may be, will be reporting his grievance against the kingmakers to the same kingmakers who will have to sit and consider his grounds or grievance and decide on it. This will definitely run foul of the rule of natural justice, that is, nemo judes in causa sua, meaning the kingmakers will be a judge in their own cause. At any rate, it is a settled position of our law that where the court considers the issue of jurisdiction at the final stage of judgment, the court should not ignore other pieces of evidence in the case that may resolve the issue of jurisdiction and must not pretend that those pieces of evidence does not exist, as doing so will violate the fundamental principle of fair hearing that requires the court to consider all evidence on an issue in determining the issue before it. No wonder Nikitobi of blessed memory, the Lord Daniel of his time, in the case of Feed and Food Farms Nigeria Limited and NNPC, in this wise took a cautious approach that rights affecting jurisdiction should be considered on a case-by-case basis, that each case is to be taken on its merit and not on the blanket principle of law or to be applied across the board to all cases affecting or relating to jurisdiction. See the cases of Abdullahi and Loko and others, Karishi and Gwagwa, the case of Wali and APC and Leary. I must say at this stage that the purport of the provision of Rule 40 of the First Defendant Constitution is to enable the first defendant resolve any intra-union dispute amongst its members amicably without resorting to litigation. CW1, 1 Solomon Onakina by its uncontroverted evidence under cross-examination when asked by learned defense counsel of the steps he took as a pioneer general secretary of the first defendant in resolving the dispute herein, answered emphatically that he wrote a letter to the Secretary General of the first defendant, and that in fact, the Secretary General stopped picking his calls and text messages since the 13th of February 2023 till date. CW1 again, while under cross-examination, when asked if he asked claimant if he took steps to get this matter to the National Delegate Conference, that is the NDC, he answered emphatically again that it is not the duty of claimant to take the dispute hearing to the NDC, but that of the NEC. The evidence of CW1 under cross-examination clearly shows that the first defendant and its executive bodies were not ready to resolve the dispute internally, as they failed to act on the letter of CW1, who is a founding member of the first defendant, seeking for an internal settlement of the dispute. As a corollary to the above issue on the competence of the suit, detailed the jurisdiction of this court to entertain the suit in its original jurisdiction, I am mindful of the decision of the Court of Appeal in the case of Nasu and Jacob and others, citation provided, which though none of the parties refer this court to, which is to the effect that any intra-union or inter-union dispute must first be submitted to arbitration before the Industrial Arbitration Panel, that is the IAP, under the Trade Dispute Act Cap 432, Laws of the Federation of Nigeria 2004, and thus cannot come to this court in its original jurisdiction, but only in its appellate jurisdiction after arbitration by IAP. The above position of the Court of Appeal has also been recognized in several decisions of this court. See Senior Staff Associations of Statutory Corporations and Government-Owned Companies, and Honorable Minister of Labor and others are on reported suit number NICN/APJ/39/2021, a judgment delivered on 10th of March 2022, Nigerian Union of Public Service Reportorial Secretariat, Data Processors and Allied Workers versus Comrade Jacob Kaura Makama and another, reported suit number NICN/APJ/392/2020, a judgment delivered on 19th April 2022. The Apex Court per ECO GSC now retired in the case of Unknown versus Saris International Limited, while relying on the decision of Toby GSC of blessed memory in the case of Effiong and Cross River SIEC, held that an issue of law or jurisdiction of court to adjudicate over a matter can be raised and determined by a court at judgment stage without the need to call for address from the parties. See also the case of Akingbulugbe versus Nigerian Romanian Wood Industries Limited, Edevie and Orowedo, Eneo and Ingere, owners of MT Marigold versus NMPC and another, citation provided. It is clear from the above abundant judicial authorities that the rule that a court must give parties a hearing when it raises an issue so motu is not without exceptions. And the exceptions are: 1, when the issue involves the court's jurisdiction, and 2, when parties fail to take into consideration the state that has bearing on the matter. In this case, parties not only fail to take into consideration the provision of the TDA on intra and intra-union disputes as regards arbitration, and also the issue herein relates to the jurisdiction of this court to entertain this case in its original jurisdiction. Thus, this court has power to resolve the issue of whether the dispute herein should be first submitted to arbitration at the IAP under the TDA before coming to this court in its appellate jurisdiction without the need to hear from parties. It is in the light of the above that I will consider the said issue of the jurisdiction of this court in respect of intra-union or inter-union dispute, which with respect to submission of a dispute hearing for arbitration before the IAP as espoused in the case of Nasu and Jacob and other supra. Ordinarily, by the doctrine of judicial precedent, this court is bound by the said authority. However, it must be noted that the doctrine of stare decisis or judicial precedent, which provides for the principle that a lower court is bound by the decision of an appellate court, operates where the issue determined by the court in an earlier case is the same or similar to the issue the court is subsequently approached to determine. Thus, where therefore an issue had not been previously raised and determined by the court, a decision arrived by the court cannot rule a subsequent one onto totally different facts or laws from those in the earlier case by a long line of decided cases. It has always been recognized that cases are to be decided based on primacy of facts. As such, the position of the law is clear that cases are to be decided on their peculiar facts and circumstances, and as such, an authority is only an authority for what it decides. See the case of PDP and INEC and others, the case of Thomas and Federal Judicial Service Commission. It is therefore expedient that the court is guided by the peculiar facts and circumstances of this case as revealed in the pleadings of the claimant. Equally of note is that the case of Nasu and Jacob and others, supra, is distinguishable from this instant case. I will explain why. In Nasu's case, the bone of contention is the leadership tussle among members of the executive of Obudu branch of the Appellants Union. They were accused of fraud, embezzlement of union fund, and gross violation of the union constitution. The branch was then plunged into crisis and disharmony leading to factions and the leadership crisis, which halted union activities in the said branch. Various petitions and counter-petitions were received by the appellant from the branch. In a bid to resolve the said crisis in the branch, the appellant, his general secretary, led some senior officers of the union to a peace and reconciliatory meeting with the respondents and others, as a result of which a memorandum of understanding, that is an MOU, was agreed upon and signed by all parties involved. Notwithstanding the peace moves, the crisis persisted with allegations that the terms of the MOU were not being observed. As a result, the NEC of the appellant directed the General Secretary to dissolve the said branch executive committee, audit the accounts and financial reports of the said branch, and thereafter constitute a caretaker committee. While the fact of this case has already captured supra, that the first defendant, CWC, suspended the claimant immediately after his arrest by NAPTIP and detention in March 2021. Claimant approached the court after his suspension by the CWC, and the court handed down an injunctive order urging parties to maintain status quo. Contrary to the order of the FCTI court, NEC flouted the order of the court, ratified the action of the CWC. Subsequently, NEC installed the second defendant as acting president, equally expelled the claimant as a member of the first defendant, and removed him as president of the union without giving him a right of hearing on an allegation of child trafficking leveled against him by NAPTIP, which is a criminal allegation whereby a defendant is presumed innocent until proven otherwise by the prosecution. The criminal case at the FCT was still pending at the court at the time, though same has been resolved in favor of the claimant in 2023, and he has been discharged from all criminal charges as revealed on record. One major distinguishable issue in this case, as opposed to Nasu's case supra, is that in this case, the claimant neither has any issue or dispute with the members or executive members of the union, nor the union itself. The only issue he had was an unproven allegation of child trafficking levied against him by NAPTIP, as opposed to Nasu's case. The problem he had was with NAPTIP and not an internal dispute or wrangling. Also in this case, as opposed to Nasu's case, whereby the national body intervened, met with the feuding members and drafted an MOU with a view to resolving their internal dispute, the first defendant in this case took it upon itself, without giving claimant a right of hearing, suspended him, and flouted the order of a superior court of record, urging them to maintain status quo, and thereby restraining them from taking any further step against the claimant. The first defendant's NEC flouted the subsisting order of court at that time, went ahead, as stated supra, ratified the suspension of the claimant, expelled him as a member, and replaced him with another person as president of the union. It is in the light of the contemptuous act of the defendants that the claimant took out a general form of complaint in this court, seeking for the declaratory reliefs captured herein before. Before proceeding with the above issue, let me at this stage take a slight detour with a view to addressing the contention of learned defense counsel in his reply on point of law to the final written address of claimant, that claimant counsel, having filed his final written address based on his originating process without any reference to his statement of fact, filed along with his originating process, has a fortiori abandoned his pleadings. And as such, there is no pleadings before the court on which claimant's case can stand on. I have to say that by the authority of the Apex Court decision in Oduola and others, and Ashcroft and another citation captured, where a party has once given a distinct notice of his claim, the onus is on the other side to show he has abandoned or given reason to believe he has abandoned his claim. The defendants who would want this court to believe that claimant has abandoned his pleading because learned claimant counsel did not make any reference to his statement of fact in his final written address have the onus of proving the said abandonment before this court. Claimant in this case, via his statement of facts, have given a distinct notice of his claim and case and called evidence in support. The defendants already joined issues with him on the statement of facts in their own statement of defense and called evidence in support of their stance. The defendants who would want this court to hold that the claimant has abandoned his claim by reason of non-reference to same in the final written address must of course prove the alleged abandonment. They have failed to refer this court to any statutory or judicial authority that supports their stance that failure of the learned claimant counsel to make reference to the statement of facts in his final written address should be viewed as an abandonment of the pleadings of claimant. It is absurd to say that because the counsel who represents a party fails to make a reference to the statement of facts in his final written address, the party has thus abandoned his pleadings. In any case, the only instance where a party will be deemed to have abandoned his pleadings is when he fails to call evidence in support of the pleadings. See the case of Ilodibia and Nigeria Cement Company Limited citation captured. Besides, assuming claimant did not even call evidence personally, which is not the case herein, he cross-examined witnesses of the defendants, extracted evidence from them under cross-examination, and as such, based on the decision of the court in PDP and Nwankwo and others, he cannot be deemed to have abandoned his pleadings, assuming he even did not call evidence, which is not the case in this hearing. See also Oyewumi and another Anoni citation provided. More so, the address of parties is only designed to assist the court. See Ndukwe and UBN PLC citation captured. Also, learned defense counsel had asked the court to strike out paragraphs 8 to 12, 21 to 37, 77 to 97, and 101 of the claimant's statement of facts. He posited that those facts are irrelevant to the facts of the case of a suspension or expulsion before the court, and as such, do not relate to the subject matter of this case. May I remind learned defense counsel that the defendants have responded to some of the above paragraphs, viz. Paragraphs 4, 9, 24, 25, 28, 35, 36, 37, 38, 41, 45, 47, 58, 59, 60, and 63 of the amended statement of defense. In fact, the facts contained in paragraphs 8 to 12 of the statement of facts, which counsel is objecting to, were also reiterated in paragraphs 9 to 13 of the claimant's written deposition at page 25 of the record, and on which learned defense counsel cross-examined claimants, that is CW4, on during trial on the 9th of January 2024. Also, the facts contained in paragraphs 21 to 22 of the statement of facts, which is part of the paragraphs counsel is objecting to, were the same facts reiterated in paragraphs 22 and 23 of the claimant's depositions, and on which learned defense counsel cross-examined claimant during trial when he asked him questions as per his depositions in paragraph 16 to 23 of his written deposition. In the same vein, counsel also pre-examined claimant on paragraphs 24 to 26 and 85 to 91 of his sworn deposition, which relates to facts in paragraphs 22 to 25 and 84 to 90 of the written statement of facts which counsel is objecting to. The mere fact that counsel pre-examined claimant on his evidence on those facts means that those facts are relevant. Now, after responding to those paragraphs in the statement of defense and those joint issues on them, and even cross-examining claimants on some of the paragraphs, he suddenly wants the court to strike them out as irrelevant on the ground that they are facts that relates to events occurring after suspension and expulsion of claimant, and thus not relevant. I'm afraid learned defense counsel cannot do that at this stage. At any rate, the Evidence Act 2011 as amended is clear as to what amounts to relevant facts, notwithstanding the time at which they occur or how distant or close they are to the fact in issue. Section 4 of the Evidence Act provides that facts which, though not in issue, are so connected with the fact in issue as to form part of the same transaction are relevant, whether they occurred at the same time and place or at different times and places. Also, Section 7 of the same Evidence Act stipulates that facts A, necessary to explain or introduce a fact in issue, or relevant fact B, which support or rebut an inference suggested by a fact in issue, or relevant fact C, which establish the identity of anything or person whose identity is relevant, D, which fix the time and place at which any fact in issue or relevant fact happened, or which show the relation of parties by whom such fact was transacted, are relevant insofar as they are necessary for that purpose. In the same vein, by Section 9 of the Evidence Act, facts not otherwise relevant are relevant if A, they are inconsistent with any fact in issue or relevant fact, and B, by themselves or in connection with other facts, they make the existence or non-existence of any fact in issue or relevant fact both probable or improbable. See also the case of Michelle Limited and another versus Pelomech Limited. Obiagu and others was Okorafo. In view of the above provisions of the Evidence Act, I cannot find how those facts in the said paragraphs of the statement of facts are irrelevant because they occurred after the suspension or expulsion of claimant. In fact, the facts averred in paragraphs 34 to 37 of the claimant's statement of facts are facts relating to his arrest by NAPTIP, and which case was part of why the first defendant suspended him as the president of the first defendant. For the above reasons, I discountenance the submission of learned defense counsel to the competence of the above paragraphs of the claimant's statement of facts. It is in the light of all the above that I discountenance the misconceived position of learned counsel for the defendants on the validity, that is the validity of the pleadings of claimants in the statement of facts. I so hold. Be that as it may, it is evident in the instant case, deduced from the statement of facts of claimant, that though the dispute herein is intra-union, however, one peculiar fact sets it apart from an ordinary intra-union dispute as in Nasu's case supra. And I will explain why. Claimant herein is alleging a disobedience to an order of the High Court of the FCT in his suspension and removal as president of the first defendant, as well as his expulsion as a member of the first defendant, which in law is contempt of court. It is one of the claimant's grounds before this court, thereby challenging all the disobedience act of the defendants to that court's order. The Apex Court in the case of Shoda Indi and others versus registered trustees of the Ahmadiyya movement in Islam, citation provided, espouse on the limit of the jurisdiction of the Superior Court of Record, like this court, and an inferior tribunal or panel like the IAP. The IAP is a panel for arbitration of trade dispute. The judicial powers of the Federation are vested in the Superior Courts of Record, one of which is this court, by virtue of Section 6 of the Constitution as amended. The Apex Court in the case of Agua and Ikewibe held that a customary arbitration is not an exercise of a judicial power under the Constitution, nor being a function undertaken by the courts. Therefore, in my view, arbitration not being a function carried out by court is not an exercise of judicial powers under Section 6 of the Constitution. The court, in the case of exploration and exploration and production Nigeria Limited and another versus FIRS and another citation provided held inter alia, while considering the extent of the powers of an arbitral tribunal, that an arbitral tribunal is incapable of exercising the judicial powers of the Federation or of a state under Section 6 of the Constitution. Thus, an arbitral tribunal is clearly an extrajudicial body engaged in the amicable settlement of a dispute between parties who have elected not to invoke the exercise of the judicial powers of the court. In my view, by Section 6 of the Constitution, the judicial power of the Federation, which includes the inherent power to consider an issue of contempt or the consequence of disobedience to court order, is given to courts and not to non-judicial bodies like an arbitral tribunal. In the case of Shoda Indian orders versus registered trustees of Ahmadiyya movement in Islam Supra, the apex court per Aniagolu GSC of blessed memory held inter alia. Thus, with respect to jurisdiction of superior and inferior courts, I quote, although the limits of authority of a court, be it a superior or an inferior court, are imposed by statute, charter, or commission under which the court is created or constituted and may be extended or restricted by similar means. It is a recognized general law that prima facie, no matter is deemed to be beyond the jurisdiction of a superior court unless it is expressly shown to be so, while nothing is within the jurisdiction of an inferior court unless on the face of the proceedings it is expressly shown that a particular matter is within the cognizance of a particular court, unquote. It is clear from the above that at common law, no cause or matter is prima facie deemed to be beyond the jurisdiction of a superior court, unless it is expressly shown to be so, and nothing is within the jurisdiction of an inferior court unless, on the face of the proceedings, it is expressly shown that a particular matter is within the jurisdiction of such inferior court. Applying the above position of the court to this case, on the face of the proceedings hearing, in view of the issue of alleged civil contempt or disobedience to court order that is present in these proceedings, as well as declaratory relief sought by the claimant, it is expressly shown that the IAP does not have jurisdiction because disobedience to court order is not an issue that can be settled via an arbitration by an arbitral body like the IAP. Again, there is nothing in the TDA which establishes the IAP that seems to confer jurisdiction on the IAP with regards to declaratory reliefs and disobedience to an order of superior court on contempt. Further to this, for the IAP to assume jurisdiction on any matter, the dispute must be apprehended by the Honorable Minister of Labor by Sections 5 and by Section 9 of the TDA, refer the dispute to settlement to IAP. It is also apparent from the provisions of Sections 5 and 9 of the TDA that the minister, not being a judge, cannot apprehend a dispute already before a superior court of record, that is the FCTI court, which order has been blatantly flouted by the first defendant and its organs. All I'm trying to say here is that the issue of civil contempt or disobedience to court order, which arose in the course of the intra-union dispute in this case, is not a dispute that is capable of being settled by arbitration, and as such, has clearly taken this matter out of the jurisdiction of the IAP. As such, the peculiar nature and the circumstance of this case, which is clearly in contradistinction from NASU's case, cannot be adjudicated upon by the IAP. It has to come to this court as a court of first instance, especially since Sections 254C, subsection 1, paragraph A and J provides, I quote, notwithstanding the provisions of Sections 251, 257, 272, and anything contained in this Constitution, and in addition to such other jurisdiction as may be conferred upon it by an act of the National Assembly, the National Industrial Court shall have and exercise jurisdiction to the exclusion of any other court in civil causes and matters, J, relating to determination of any question as to the interpretation and application of any paragraph 5, trade union dispute or employment dispute as may be recorded in a memorandum of a settlement or paragraph 6, trade union constitution, the constitution of an association of employers, or any association relating to employment, labor, industrial relations, or workplace. It is therefore clear as daybreak from the above captured constitutional provisions that this court is the only one-stop justice court in this clime that has exclusive jurisdiction to holistically entertain and adjudicate on trade dispute generally to finality and completely determine all matters in dispute between parties. See Section 14 of the National Industrial Court Act. It is from all the reasoning above, duly entrenched in law, that I find that this court, being a superior court of record, is clothed by Section 6 and Section 254C1A and J of the Constitution with exclusive jurisdiction over trade disputes. Consequently, I hold that the peculiar facts and circumstances of this case demands that only this court can adjudicate on the relief sought by the claimant and no other, not even IAP. Thus, it is not fatal for claimant not to have submitted to the process of arbitration in Part 1 of TDA before coming to this court, I so hold. Another grounds of the defendant, as espoused by learned counsel for the defendants while arguing issues 3, 4, and 5 together in his final written address, is that parties are addendum on the pendency of a suit by claimant on the same subject matter, and also a pending appeal by defendant against the ruling of the High Court of the FCT on the same subject matter, and thus this suit is an abuse of the process of court. Learned counsel equally proceeded that claimant alleged the enforcement of his fundamental right in the pending suit, but it is common knowledge that enforcement of fundamental right is governed by its rules made further to a special procedure under Section 46 of the Constitution, which by the pleading and evidence before this court is not. He also submitted that the pleadings of the claimant in this suit do not disclose any reasonable cause of action. More so, claimant's action before the court is premature. He relied on the cases of Attorney General of Lagos State and Attorney General of the Federation, the case of Ode and Uzo, and the case of Karashi and Gwagwa Supra. On the allegation of denial of fair hearing, counsel contended that it would not automatically enable a court to assume jurisdiction. However, the court will look at the nature of the matter of which denial of fair hearing is being complained of. He went on to submit that in any event, it has been held by the Apex Court that within the meaning of Section 36(1) of the Constitution, fair hearing becomes applicable only when the authority accused of the denial of it is government or authority. He submitted that even if the suit had disclosed any reasonable cause of action which is not conceded, the apparent deficiency in drafting reliefs is fatal to the validity of this suit. He cited in support of his assertion the case of Gabriel, Ativi and Kaba Metal Nigeria Limited, Amodu and Amode, Ibama and Shell Petroleum Development Company Limited. Learned claimant counsel in his own final written address, in response to the objection raised by the defense counsel, submitted that claimant's action is not an abuse of the court process, as it is this court that has jurisdiction over claimant's action by virtue of Section 7 of NICA and Section 254C of the Constitution. He submitted that claimant only approached the FCTI court for the enforcement of his right to fair hearing. He relied on the case of Afro-Arab Investment Limited and another and AMCOM, and Onohe and Federal Republic of Nigeria, Engineering Enterprise of Niger Contractor Company of Nigeria versus AG Kaduna State, and the case of Ukata and others versus Indinaize and others. He posited that this suit is not an abuse of the process of court, as same was rightly submitted to the court having jurisdiction to entertain the specie matters submitted to it. He posited that the suit initiated at the FCTI court is for enforcement of his fundamental right and thus urged the court to so hold. Additionally, counsel submitted that claimant case has disclosed a reasonable cause of action as same is contained in his pleadings. He cited in support the cases of Yusuf and others versus Akindipe and others, Thomas and Olufosoye, Jackson and British Medical Association, citation provided. First, as regards the argument that claimant's action is an abuse of the process of court, it has to be stated that the issue of abuse of court process is an issue of jurisdiction, because if the court is satisfied that any proceeding before it is an abuse, it has the power to decline entertaining it. See Usman and Baba. It must also be noted that there is no precise definition of what an abuse of the process of court is, or a closed-ended list of what will amount to an abuse of process of court. However, judicial authorities are in agreement that multiplicity of court processes on the same subject matter before one or more courts of competent jurisdiction and between same parties to the irritation or annoyance or harassment of other party is an abuse of court process. The abuse lies in the multiplicity and the manner of the exercise of the right rather than the exercise of the right per se. See Lokbobiri and Ogolo, the case of Commissioner Education, Imo State and Amadi. It must be pointed out that there are no hard and fast rule in detecting abuse of court process, but courts are enjoined to examine each case, predicated on the facts and circumstances of each case in order to ascertain if they display abuse of court process or not. See by Courtney Limited and ASO Savings and Loan PLC. The court will compare the processes in the order suit with the present one in order to determine if there was an abuse. I have compared the earlier suit and the present one. First, let me say that this court is a court given exclusive jurisdiction in respect of trade union and trade disputes in virtue of Section 254C1A and J of the Constitution, as I've quoted earlier, and no other court shares that jurisdiction with this court. As such, this court is the only court of competent jurisdiction in respect of claimant's action respecting the trade union and trade dispute. Also, claimant in the earlier suit number FCT/HC/BW/CV/87 between parties herein as shown by Exhibit B21 was only challenging his suspension as president of the first defendant by the CWC therein, who are also the defendants herein, and his replacement by the third defendant without fair hearing. In fact, the earlier suit was filed on the 12th of March 2021 before claimant was eventually removed as president by NEC of the first defendant and before his eventual expulsion as a member of the first defendant. The instant suit before this court, claimant is challenging not only claimant's suspension as president of the first defendant by the CWC, but also his eventual removal as president by the NEC of the first defendant in defiance of the court order in suit number FCT/HC/BW/CV/87, together with his subsequent expulsion as member of the first defendant and alleged perpetuation of the second defendant in office as Secretary General after his retirement. In effect, the totality of claimant's case in this suit in this court is, as stated earlier in this judgment, is challenging the totality of all the acts or actions of the defendants. In essence, the totality of the claimant's alleged travail in the first defendant is what is before this court, as against the previous suit that was only challenging his suspension as president by CWC. As such, I find that this present suit is not totally the same in subject matter and in all ramification with the suit in FCTI court. In the case of SPDC Nigeria Limited and Tenalo and others, the Court of Appeal, while considering what will amount to an abuse of court process, held that two cases may arise from similar transactions and still not be an abuse if the subject matter are not the same. In the case of PDP and another versus Sume and another citation provided, where the Apex Court held those, and I quote, there may be a situation where there exists multiple transactions between the same parties. Such multiple transactions between the same parties may oftentimes give rise to multiple causes of action. Each cause of action in that situation gives rise to a distinct right of action. The exercise of such right of action in such a situation between the same parties cannot be said to be multiplicity of actions between the same parties in respect of the same cause of action to warrant a plea of abuse of court process. Where therefore there exists a pending suit on a cause of action different and distinct from another in the subsequent suit between the same parties, the existence or pendency of the previous suit on an entirely entirely different cause of action between the same parties does not make or constitute a subsequent suit on an abuse of the court process. Rather, what makes a subsequent suit an abuse of the process of court is the institution of a fresh action between the parties and on the same subject matter against the same opponent on the same issues when the previous suit has not yet been disposed of, unquote. The final removal of the claimant as president of the first defendant and his expulsion as a member of the first defendant came after the previous suit, and the alleged perpetration of the second defendant in office are all different cause of actions giving rise to the present suit. In the instant suit, at best, the two cases emanated from the similar transactions, but certainly not brought on the same grounds as to constitute abuse of process. I wish to reiterate here that this court is the only court in this clime that has donated to it exclusive jurisdiction to entertain and adjudicate on all the issues and the relief sought by the claimant in this case. Although the claimant's action at the FCTI court is on his suspension and breach of his fundamental right, his expulsion and eventual removal from office as president of the union are cause of matters exclusively within the jurisdiction of this court, to which the FCTI court cannot share. In any case, learned counsel for the defendants have submitted in paragraph 5.01 of his final address that the previous suit, which was only challenging claimant suspension by CWC, is subject of a pending appeal before the Court of Appeal. The substance of the alleged appeal is not before this court, as the notice of appeal has not been placed before this court, which is fatal to the argument of the defendants on the abuse of the process of court, unless there is a pending application to appeal. An appeal is entered. It cannot be properly said that there is an appeal pending before the Court of Appeal, and this court cannot speculate on that. All I'm trying to say from the above is that this court is the only competent court in respect of trade union actions, and that the present suit cannot be said to be a duplication of a previous one in suit number NIC and FCT/HC/BW/CB/87, as there are sufficient differences between the said suit and this present one to constitute different cause of action. It is in view of the above reasoning that I discountenance the submission of learned defense counsel that the present suit is an abuse of court process. I so hold. As per the absence of reasonable cause of action, it is worthy of note that absence of reasonable cause of action may apply to divest the court of the jurisdiction to try a case. Thus, reasonable cause of action is only linked to jurisdiction in the sense that if an action does not disclose reasonable cause of action, the court will not exercise jurisdiction to try same. See Odumegwa and Ibezim, the case of Ohaji and Unamaka, the case of Adetona and Edet. Claimant in his statement of claim or statement of fact is expected to disclose reasonable cause of action or complaint for his case to be competent before the court. This is because disclosure of cause of action is a sine qua non to the exercise of jurisdiction by the court. A reasonable cause of action refers to the facts or set of facts that gives the claimant right to sue. As such, to disclose reasonable cause of action, the statement of facts herein must set out the legal rights of the claimant, and the obligations of the defendant must go on to set out the facts that constitute infraction of his right or failure of the defendant to fulfill its obligation in a way that if there is no proper defense, the claimant will succeed. CPDP and EDD, and the case of Oga and Igbe. Thus, when the issue of reasonable cause of action is to be considered, the court is to look at the statement of claim or facts. See Fidelity Bank PLC and MC Industries Limited. In the instant case, the claimant's statement of facts upon perusal disclosed reasonable cause of action as it contained triable issues like the alleged non-compliance with provision of the constitution of the first defendant in his suspension as president of the first defendant by the Central Working Committee, the alleged non-compliance with the order of court in his removal by NEC of the first defendant and his eventual suspension. Whether claimant can prove this allegation is a different kettle of fish. However, there are questions fit to be tried in the claimant's statement of fact, which, if not properly traversed, may succeed. It is in the light of the above that I find that claimant's action has disclosed a reasonable cause of action. I so find and hold. Another leg of the objection to the jurisdiction of this court is the submission of learned defense counsel while taking issues 1 and 2 in his final written address together. According to him, these issues border on the jurisdiction of this court to entertain this suit, cited in support of his assertion the case of VF Worldwide Holdings Limited and Dana Services Limited. He posited that claimant can only approach this court where he can show that there is a justiciable dispute between him and the defendants involving his personal interests in which a question of determination of his rights and obligations has arisen without which the court cannot look into it. He cited in support of his position section 6 subsection 6b and 36(1) of the Constitution and the following cases: Enang and Asukwo, Sani and APC, PDP and Silva. He further argued that the position of the law is that if members of the association or union decide at a meeting that their president or a member be expelled or removed, what is withdrawn from such member is a political right, which is in the nature of a privilege. Hence, the court cannot intervene because it is an internal affairs of the union, that is an intra-union dispute. Cited in support of the following cases: Aliyu and APC, and another versus Larry and others, Ibrahim and Usman, Olofu and Itodo, Onuara and Okafor, Dalatu and Turaki, Nongo and Achado, Abdullah and Argungu, Ufomba and INEC. Learned claimant counsel on his part in his final address submitted that authority of this court to assume jurisdiction over a case is determined generally by statutes and then pleadings. He cited in support of his position section 7(1)(a) to C of NICA, section 254, C1 and 2 of the Constitution, and the case of Metal Construction West Africa Limited and Miglore and others. He submitted that the court will only be reluctant to interfere with internal affairs of the union of the first defendant where its operations are carried out in line with the dictates of all relevant laws. He cited in support the case of NCSU versus ECASA and others. In addressing the above contentions, I must first say that there is no doubt from a line of abundant judicial authorities that court's jurisdiction is hosted in matters pertaining to the internal affairs of a voluntary organization, be it a union or a political party. Court's jurisdiction is as such hosted because of the non-justiciability of the subject. See Ufomba and INEC and others, Mbanefo and Boloku and others, Uzodinma and Uzonaso, PDP and Silva Supra. Trade union is like a club or a political party, which is a voluntary association. It has its rules, regulations, guidelines, and constitution. Members join the party on their own free will. By joining, they have freely given their consent to be bound by the rules, regulations, or guidelines or constitutions of the union. These rules of the union must be obeyed by all members of the party, as the party's decision is final over its affairs. Members of a voluntary association would do well to understand and appreciate the finality of an association's decision over its domestic or internal affairs. The rationale for the above position of non-justiciability of internal affairs of a voluntary association lies in the recognition right to freedom of association in section 40 of the Constitution as amended, which provides thus, and I quote, "Every person shall be entitled to assemble freely and associate with other persons, and in particular, he may form or belong to any political party, trade union, or any other association for the protection of his interests," unquote. See also the case of Anielo and others versus Madua Bunu and another citation captured. Nonetheless, there are instances where the jurisdiction of a court will not be hosted, and which situation the court has right to intervene. In this regard, I would like to apply the principle as enunciated in the case of Alhaji Balarabe Musa and PRP, People's Redemption Party. This is Peade Farasin, CJ, and which decision was relied on by the Supreme Court in the case of Mbanefo and Moloku and others, Supra. I quote, "The court will not interfere In a case like this one, where members of a voluntary association have come to a decision within the provisions of their constitution, even if the decision is unreasonable, circumstances have not arisen by which the court ought to intervene. As a voluntary association, it has the right to lay down its own decisions even when they are unreasonable. They should be obeyed, or the member in disobedience is entitled to quit. The party is in its own right supreme over its own affairs. This must be said loudly and clearly. Unless it has violated its own constitutional provisions, the court will not interfere, unquote. It is clear from the above dictum of Adefara CCJ that the jurisdiction of the court will only be ousted where a voluntary association carries out an act in line with its constitution, even though unreasonable. Also, the court will interfere where such voluntary organization has breached the contractual right of any of its members, or where the court is expressly given such power by statute. Also, I must add that under the present dispensation, especially with the view to the recognition of this court as a superior court of record in the Third Alteration Act 2010, which is the present and prevailing dispensation, the jurisdiction of this court on trade disputes and trade union actions have been circumscribed within the confines of Section 254A to E of the Constitution and under NICA 2006. By the provision of Section 54 of NICA, which defines trade dispute and intra-union dispute, and in which category the dispute herein falls. Section 54 of Trade Dispute Act, Trade Unions Act, hereinafter refers to as TUA, also defines what a trade dispute is. The Trade Dispute Amendment Decree 47, 1992, which is the one of the amendments to the TDA, removed the dichotomy created before on the application of procedure in Part 1 of TDA as regards inter- and intra-union dispute. This it did by amending the jurisdiction of the National Industrial Court in respect of trade dispute cases to include intra- and inter-union disputes. Section 1A, 1 and 2 thereof stipulate thus, and I quote, subject to the provisions of Section 3 of Section 20 of this Act, no person shall commence an action, the subject matter of trade dispute or inter- or intra-union dispute in a court of law, and accordingly any action which prior to the commencement of this action shall abate and be null and void. Subsection 2, notwithstanding the provision of the Constitution of the Federal Republic of Nigeria 79, any interim or interlocutory order, judgment, or decision made by any court other than the National Industrial Court established under this Act, in respect of trade dispute, inter- or intra-union dispute prior to the commencement of this section shall cease to have effect, unquote. Thus, by this provision, the only court of record that has jurisdiction in respect of trade dispute or any trade union is the National Industrial Court, as stated here before in this judgment. See also the decision in the case of Udro and OHMP, and Section 254C1A and J of the Constitution, and Section 7 of NICA. As such, a distinction must be drawn between the internal day-to-day activity of a voluntary association like a trade union, as we have in this instance, and the statutorily defined duties and obligation of same, which must be guided by set out rules and regulations. Please mute yourself. Please mute yourself. A breach of which would give an aggrieved member a right of action in his court to hear and determine same. All I'm stressing here is that under the present dispensation, a trade dispute or any matter relating to a trade union is a justiciable action that can be tried by the National Industrial Court, especially where the subject of the action involves non-compliance with the provisions of the Constitution of the said trade union, leading to a breach of the contractual right of any of the member or members or any other tribal issue. Thus, says the Constitution of Nigeria, captures supra. Having made clear the current position of the law with regards to the jurisdiction of this court to entertain matters arising from domestic or internal dispute of a voluntary association like a trade union, the next hurdles to examine is if the claimant claim fall within the ambit of what will be termed domestic or internal affairs of the first defendant, and in which situation the claimant grounds, which is the subject matter of this action, can be found in a statement of facts. His grounds is against the non-compliance with the provisions of the first defendant constitution in his suspension as president and eventual removal as same, and expulsion from the first defendant in defiance of a court order. From the above facts, it is clear that claimant raised the issue of non-compliance with the provision of the constitution of the first defendant and an order of court in the decision for him to step aside as president of the first defendant and his eventual removal. Assuming the contention of claimant as to the non-compliance with the constitution is non-justiciable, which fact is not conceded, we once say that alleged failure to comply with an order of a court of record, whether wrong or right, is also non-justiciable. The answer is undoubtedly in the negative. The claim of a claimant, in my respectful view, is justiciable in the light of the provision of Section 254C, 1A, and J of the Constitution, and the peculiar facts of this case. Thus, I find no reason why the court's jurisdiction will be ousted, especially as this is now an intra-union dispute, which is a trade dispute within the confines of the law, and one which this court has exclusive jurisdiction over cogito ergo sum per contra the argument of the defendants. I find the claimant's action justiciable. In view of all the reasoning above, I resolve question 1 in favor of the claimant and against the defendants. Now to issue 2. Learned counsel for the defendants in his reply on point of law to the final written address of claimant had submitted that a statement of claim supersedes the writ, and as such, since the complaint filed by claimant contains 19 reliefs, while the statement of facts contains 13 reliefs, the court will only be guided by the relief sought by claimant upon seeing the final reply on point of law. The court will only be guided by the relief sought. Claimant, upon seeing the final reply on point of law of the defendants, filed a motion on notice on the 12th of April 2024. According to the arguments of claimant in the motion, while relying on Order 26, Rules 1, 2, 3, 4, 7, and 9 of the Civil Procedural Rules of this court, and the English case of Kelly's case 15, Co-Rep Rogue's case, on the exercise of the discretionary powers of the court, is in order to bring the statement of facts in line with the complaint. He also submitted while relying on the case of Melio Fonwa and Egbonike, the case of NUC and Ali and another, that it can only be brought where it will not overreach the defendant or where it is brought to introduce a new fact or cause of action to the case. He rely on the case of Laguro and Toku, Okolo and UBN, Osho and Akpe. The defendants, in their reply on points of law to the motion for amendment, submitted that it is too late for claimant to amend his statement of fact as he sought to do, and will occasion miscarriage of justice. He relied on Section 36 of the Constitution, submitted further that the statement of facts automatically supersedes the complaint and thus cannot be aligned to it again. He called in aid the cases of Sharing Cross Educational Services Limited and Umaru Adamu Enterprises Limited and 2 others. He proceeded that the additional 6 reliefs cannot therefore be added again to bring the statement of facts in line with the relief sought in the general form of complaint. He also submitted, while relying on the case of Umezin and AGF, that when the statement of facts is deemed abandoned and liable to be struck out to allow an amendment to same, will occasion miscarriage of justice. He also relied on the case of Ifeanyi and Ogba, the case of PDP and Silver Supra, Tukul and UBA. He equally submitted that the authorities relied on by claimant in his support of the motion for amendment is distinguishable from the case at hand. He relied on the case of PDP and INEC Supra, the case of Akaolisa and Akaolisa. It is tried that an amendment can be made at any stage of the proceedings before judgment. See Owosu and Atiko. In fact, Owosu and Atiko, Fagbule and Rodriguez. In fact, the amendment of pleadings of parties is a matter within the discretion of the court, and whether leave will be granted or not will depend on the facts and circumstances of each case, and which discretion ought to be exercised judicially and judiciously. See Awoshika and Akinwonu, the case of Imbezim and Elebeke. Thus, where a court is faced with an application for amendment of pleadings, while it should strive to maintain a balance, it must have an open mind and be liberal enough to allow or grant an amendment where the demands of justice and fair play call for it. In fact, the court in the case of AG Lagos State and CUS Limited, citation captured, held that the court in exercising its power of amendment must hear both parties before determining the application for amendment, as objections to amendment are usually based on timing and substance, and more so when the application is made at the address stage. Courts will allow amendments to pleadings rather than enter judgments in ignorance, which ought to be known before the right of parties are finally decided. See Egwa and Egwa citation provided. A long line of authorities have generally laid down situations when a party will be allowed to amend its pleadings to include: 1, at any stage of the proceedings; 2, when the amendment will bring the real issue in controversy and will not occasion injustice to the other party. See the case of CCG Nigeria Limited and another versus Odorenyi, the case of NBC PLC and Ubani, Honey Crown Products Limited and Shell Electric Manufacturing Company Limited, the case of Concord Press Limited and Ubijo. The Supreme Court in the case of Eze and Ene has held that an amendment of pleadings after evidence has been called and concluded will only be justified or allowed on the premise that evidence in support of it is already in evidence, so that it is necessary and in the interest of justice to allow amendment in order to make the pleadings or claim accord with evidence on record. In the instant case, according to claimant, all he seeks to do is to amend the relief part of his statement of facts to include 6 other reliefs which were captured in his complaint in order to bring the statement of facts in line with the complaint. I perused the claimant's statement of facts and found that only 13 reliefs were sought therein as against 19 in the general form of complaint. I've also perused the claimant's general form of complaint with particular attention on the endorsement of a release on it at pages 7 and 8 of the record. And I've compared same with the supposed amended statement of fact filed by claimant, particularly the release part at pages 1,625 to 1,626 of the record. And I find that he merely wants to seek the same reliefs that were sought in the general form of complaint in his amended complaint. On the authority of Ogolo and IMB Nigeria Limited, amendment of pleadings can even be granted at the address stage or after the address stage. See also Nwakwo and Nwakwo, where the Apex Court held that it is the principle of law that very late application for amendment of pleadings and other processes of court will be granted so long as the interest of justice is thereby served. It is pertinent to say at this stage that by the nature of the amendment sought herein, it did not require calling further evidence. It was merely to capture the reliefs in the statement of facts as sought in the complaint in order to bring the statement of facts in line with the complaint and in line with the evidence already before the court. The intention is to lay before the court the entire release which claimant intends to seek. However, I'm mindful of the circumstances surrounding the said error. I'm equally mindful of the fact that Leonard Claimant Counsel did not make the application for amendment on his own volition. He made it after the receipt of a reply on point of law of the defendants to his final written address, wherein the issue was raised, and argued that since statement of claim supersedes the writ, the 13 reliefs sought in the statement of facts supersedes that in the general form of complaint. The Apex Court in the case of Eze and Ene Supra at page 333, paragraph A to B, cautioned that although an amendment of pleadings can be made at any time before judgment, notwithstanding the wide latitude, the intention is not to leave the consideration open-ended and without proper control, so as to create a floodgate of an abuse of discretion. The court in that case at page 333 at paragraphs F to G. Also, parties are enjoined and must be aware that instituting an action must first require great consideration and caution, which should give cause for careful and proper planning. Please, please, please mute your phone. I don't want to hear any noise at the background, please. I'm reading a judgment. Mute your phone. Notwithstanding the above, the apex court in the above case still affirmed the position of the Court of Appeal on the amendment sought by the defendant in that case after close of evidence, because according to the court, it does not require calling further evidence. However, it needs be stated that cases are to be decided based on their own peculiar facts and circumstances, which is the reason why authorities should only be followed, giving consideration to their factual belief as reasoned earlier in this judgment. In this instance, Leonard Defense Counsel had in his reply on point of law to the final written address argued that the reliefs before the court are the 13 reliefs in the claimant's statement of fact and not the 19 in the general form of complaint, as the statement of fact superseded the complaint. It was only then that Leonard Claimant Counsel now woke up from his slumber, realizing his tardiness, filed the application for amendment of the statement of facts to add the remaining 6 reliefs to the statement of facts. It would have been a different thing entirely if it was counsel that discovered the error on his own, and not after Leonard Defense Counsel had raised the issue of the reliefs in his reply on point of law. Thus already joined issues on this. In the case of Aina and Jinadu, Nikki Toby, JC as he then was, now of blessed memory, said thus, I quote, "A court of equity should never allow a cunning or crafty application to lord over an amendment sought mala fide at the detriment of the adverse party. In order to ensure that justice is done to the parties, the court should open its eyes wide and with a meticulous and searching mind come through the entire application," unquote. Although, by the uncontroverted facts deposed to by the claimant in paragraph 4 of the affidavit in support of the motion for amendment, the issue at hand was caused by the inadvertence or error on the part of the claimant counsel, who only discovered the error upon the receipt of a defendant's reply on point of law to his final written address. Admittedly, it has never been the intention of the law to punish litigants for the errors or sins of their counsel. See Stanbic IBTC Bank PLC and LGC Limited, Adeleke and Oyetola. The apex court, while driving home this point in the case of Nwaku and Nwaku Supra, at page 294, paragraph H, held that it is tried that a delay in taking a necessary step in the proceedings for which counsel can be held responsible should not be laid at the door of the litigant, especially since the fundamental object of the adjudication is to decide the rights of parties and not to impose sanctions merely for mistakes they make in the conduct of their cases. See your local government and Akwa Ibom state government. However, the court should be mindful of how it applies the above rules. The apex court in the case of NNPC and Sam Fadek and Sons Limited held that the rule that mistakes of counsel should not be visited on litigants does not envisage mischief, ineptitude, nor strategic blunders, and the rule cannot be applied to foist injustice on another party, nor will the rule apply in clear case of abuse of court process. See also the case of Isitor and Fakorede, citation provided. In the instant case, it would have been a different issue entirely if Leonard Claimant Counsel had been the one, like I stated earlier, to discover the alleged error stated and had raised it himself, different from the way it happened in this case. In fact, the defendant in this case did not raise the issue of the supersession of the complaint by statement of fact with respect to the relief sought in this case in their final written address, not until in their reply on point of law. Thus, there was an ample time for Leonard Claimant Counsel
Does he have
discovered
where is that his
mistake
account?
whilst writing the claimant's final written address before the defendants raised it in their reply on point of law, and which he is now seeking to remedy by the application for amendment after the defendants had raised an objection to it. Assuming Learned Defense Counsel had not raised the issue of supersession of the complaint by the statement of facts in his reply on point of law, it means that Learned Claimant Counsel would not have known of the said error, and which the court will have raised in its judgment and decide based on only the reliefs in the complaint. If Learned Claimant Counsel had been diligent in his work, he will have noticed the error made on his part in not capturing the relief sought in the general form of complaint in the claimant's statement of facts. It should be unequivocally stated here that judicial impartiality is the foremost attribute of the rule of law. And which enjoins the court to treat parties equally with fairness, impartiality, integrity, and deference, which this court has chosen to do throughout the proceedings, irrespective of barefaced deliberate attempts by parties and their counsel, in this case, to denigrate the judice. I see this bench as the position of the Almighty God, the judge of all flesh, who by his predeterminate counsel has chosen me, a mere mortal, to sit in his place and judge his people. I therefore fearfully reverence the giver of that grace in ensuring that I dispense justice to all parties before this court without fear or favor, affection, or ill will, in accordance with the judicial oath to which I subscribed 11 years ago. I am also guided by the Holy Writ in the book of Deuteronomy chapter 1, verses 16 to 17, I quote, "And I charge your judges at that time, saying, hear the cases between your brethren, and judge righteously between every man and his brother, and the stranger that is with them. Ye shall not respect persons in judgment, but ye shall hear the small as well as the great. Ye shall not be afraid of the face of man, for the judgment is God's." Unquote. And in the book of Job, chapter 36, verse 6, which says, I quote, "Let me be weighed in an even balance, that God may know my integrity." Unquote. See also the case of PDP and Muhammad, citation captured. Now, back to the issue on amendment. I find that it will not accord with justice and fairness to allow claimant, after the Learned Defense Counsel had in his reply on point of law raised the issue of supersession of the complaint by the statement of fact with respect to the relief sought, to bring an application seeking to amend the release portion of his statement of facts in order to defeat the arguments raised in the reply on point of law. The Supreme Court in the case of Agumadu and Agumadu held that there are mistakes of counsel that a litigant will be made to bear the brunt. See also Incorporated Trustees of LSMN versus Ekato. I am of the respectful view that the present suit falls within the sphere of such cases where litigants will be made to bear the mistake of his counsel. To allow this application in the circumstances of this case after the defendant had raised the issue pertaining to the said reliefs in their reply on point of law will be a travesty of justice, as it will amount to allowing claimant to have a second bite at the cherry to the detriment of the defendants. If one allows this, a time will come that litigants who discovered mistakes made by them in their cases owing to the final addresses of their adversaries will turn around to use the process of the court to overreach the other party, hiding under the excuse of mistake of counsel. It is in the light of the above that I refuse the amendment to the statement of facts sought by the claimant via the motion on notice filed on the 12th of April 2024, and thus strike out the proposed amended statement of fact filed pursuant to the said motion at pages 1,617 to 1,628. Accordingly, issue 2 is resolved against the claimant. Now to issue 3. Let me first consider certain shortcomings in the final written address of the defendants, which ordinarily ought not to be. The written address of the defendants in this case is more than 35 pages, contrary to the provision of Order 45 Rules, Rule 2, Sub-Rule 2 of the rules of this court, which provides those, I quote, a written address shall not be more than 35 pages, set out in paragraphs and numbered serially, unquote. Then the defense counsel filed a 40 pages final written address without seeking the leave of court to depart from the provision of Order 45, Rule 2, Sub-Rule 2 of the rules of this court, which makes it mandatorily for written address not to exceed 35 pages. By the provision of Order 45, Rule 1 of the rules, which address of the rules, such address could be declared incompetent. In the recent decision of this court in an unreported suit number NICN/ABJ/321/2023, the case of our Law Williams Nwako and head of Civil Service Federation and others, delivered on 21st of May 2024, the Kanyib J, the president of this court, cautioned counsel on the need to comply with the above provisions. It must be noted that rules of court are meant to be obeyed. However, I bear in mind the position of the Court of Appeal. In a similar situation in the case of Governor of Rivers State and another judge and another citation captured, where it was held that the rules and procedures are in fact meant to serve the interests of justice as handmaids of the law, to help the parties to get the justice enshrined in the substantive law. The rules cannot therefore be made to operate as a cog in the wheel of justice, to be used to deny a litigant the opportunity to be heard on the merit. The court in that case held that the excess of 5 pages in the written brief will be overlooked in the interest of justice. It is in the light of the above that I cautioned counsel to desist from such act, but will in the interest of justice that the Court of Appeal overlook the excess of 5 pages in the final written address of the defendants.
Thank you.
Next, let me address the contention of the defense counsel in his final written address to the competence of a consequential reply filed by the claimant to the amended statement of defense of the defendants. The defense counsel submitted that the reply is in the nature of an unauthorized amendment of the statement of fact, and as such is not properly constituted. He submitted that not every averment in each paragraph in the statement of fact, consequential amended reply to statement of defense that is material or relevant to a case cited in support is Order 30 Rules 1, 2, 3, Order 3 Rules 8, 9A, and 10B, 2 and 3 of the Rules of Court, and the case of Amakeze and Inze Petroleum Company Nigeria Limited, Obali and Ekwelendu. He also submitted, while relying on the case of Olubodu and Lawal, Akeredolu and Akinremi, and page 41 of the House Breeze Laws of England, fourth edition, that in the event of this case that there is no counterclaim, the apparent object of claimant is to deny allegation in the amended statement of defense. Therefore, submitted that claimant's consequential amended reply to amended statement of defense is a catalog of repetitions of modification of addition to an expansion of the original statement of fact, as well as a strenuous fact, which, if accepted by the court, will amount to springing surprises at the other party, thereby violating the defendant's right to fair hearing. Cited in support of this assertion, the case of Okoro and Egbuo, and Section 36(1) of the Constitution. He posited that claimants cannot plead new facts in his reply, and that averment in the claimant's reply is offensive to the principle that there must be an end to litigation and also offends the defendant's right to fair hearing. In response to the above, learned claimant's counsel urged the court to discountenance the issue raised with respect to the reply to the claimant's or a reply of the claimant. He submitted that claimant has the right to file a reply when new issues are raised in the amendments made by the defendants to their statement of defense. Cited in support is the case of Adaka and Omesa. Submitted that the amendments to the statement of defense brought in new issues that claimant ought to respond to, specifically facts averred in paragraph 64 to 86 of the said amended statement of defense. He also submitted about the 30 rules, Rule 16 of the rules of this court. The defendants are not allowed to raise any technical objection to any pleadings on the ground of want of form. Such is objection to the statement of fact and the reply cannot stand. Submitted further that in this instance where the defense sought the leave of court to introduce new facts to the statement of defense, claimant was equally at liberty to file a consequential reply, and learned defense counsel cannot be saying he ought to be given an opportunity to respond to the reply. He argued that by law, the defendants, if they have any further ground of defense, will file a further defense not necessarily tied to the reply. Cited the case of Ezekwe and another on Rai and another 30 will file the rules of this court. He argued further that the defendants failed to show the prejudice that has been occasioned to them by the final statement of fact and the reply of claimant. Proceeded that the court does not do technical justice but substantial justice. It relies on the 30 Rule 16 of the rules of the court, the case of Mercantile Bank Limited and Feteco Nigeria Limited. The rule of practice in pleading is that when no counterclaim is found, a reply is generally unnecessary if its sole object is to deny allegations contained in the statement of defense. The proper function of a reply is to raise in answer to the defense any matter which must be specifically pleaded, which made the defense not maintainable, or which otherwise might take the defense by surprise, or which raised issue of fact not arising out of the statement of defense, or where because of the defense filed, the claimant proposes to lead evidence in rebuttal or to raise issues of fact not arising out of the statement of claim or fact and the statement of defense. See the case of Zarewa and another vessel, Pogore and others. The case of Alao and ACB. Put differently, a claimant is entitled to plead facts in a reply to the statement of defense of a defendant, which contradict the case made out by the defendant or respondent in its defense, and show that the case is not plausible. Where such facts are pleaded, they cannot be regarded as new issues. The defendants to amend their statement of defense in this was at liberty to respond to the new facts so raised by the defendants in their amended statement of defense. Otherwise, they'll be deemed as admitted. See Maba, Mije, and Otto. Phillips and EOC Industries Company Limited. Claimant in this case filed a consequential reply and responded to the new issues raised by the defendants in the amended statement of defense. I do not see how those facts are new facts, especially as they were in response to the amended statement of defense of the defendants, which had earlier introduced new facts. Learned Defense Counsel in paragraph 618, 6.18 and 6.21 of his final written address at pages 1,524 to 1,525 of the record, had placed heavy reliance on the case of Okoro and Ogbua Supra, suggesting that the Supreme Court in that case at pages 22 to 23 of the report held that reply to statement of defense should not be allowed to overreach the other party or spring surprises on the other party. I must say that counsel distorted the facts and holding of the above authority to suit himself, because the Apex Court in that case at pages 22 to 23, where counsel quoted from, was obviously referring to a different procedure, different from reply. The court was referring to the procedure for admitting further evidence on appeal. The court held, I quote, "The procedure for admitting further evidence on appeal is not at the disposal of an indolent or not diligent litigant. The procedure cannot be used for the repair of a case at the end of trial. It is not designed to overreach the other party or spring up surprises at the other party when the appeal is heard." Unquote. I need to let learned counsel know that while he is at liberty to vigorously canvass the case of his client, he derogates from his duty to assist the court in attaining justice as an officer of the Temple of Justice to misrepresent the facts and holding of a judicial authority relied on in order to suit his purpose. It is totally unacceptable practice. See the case of MVPs and others versus FRN. It is in the light of all reason above that I find that the argument of learned defense counsel that the averments in the consequential reply of the defendants breach the defendant's right to fair hearing is obtuse. Please unmute yourself. Please unmute yourself. Unmute yourself. Unmute yourself. Unmute yourself. Now to the merit of the case at hand. Sorry, mute your phone, mute your phone. I don't want to hear anybody's voice underground. Mute your phone. Mute your phone, mute your system or tablet or whatever you are using on this platform. Now to the merit of the case at hand. Admittedly as submitted by learned counsel for the defendants, statement of claim hearing as statement of fact supersedes the writ hearing as complaint. See Alliance International Limited, SK International Enterprise Limited. Aliko and Oko. The court having not allowed the amendment sought by learned claimant counsel will only be guarded by the relief sought in the statement of fact, which reliefs are 13 reliefs. Let me start by addressing the issue of claimant's expulsion. As a member of the first defendant, I'm taking this method because the right to contest for or hold any position in the first defendant is part of the incident of membership. Thus, there is need to address whether claimant is still a valid member of the first defendant before addressing whether claimant has a right to still retain his position in the presidency of the first defendant. According to claimant, vid paragraph 67 and 72 of the statement of fact averred that the court ordered that parties should maintain status quo made on the 15th of March 2021 was served on the defendants. He also averred that the defendants, in defiance of court order urging parties to maintain status quo, convened an illegal meeting at the eve of the birthday of the second defendant when he was to retire on the 16th and 17th of August 2021 in Lagos, and therein a decision was taken to expel him from the membership of the first defendant and also extend the state of the second defendant. Please don't disturb the court sitting, please. The defendants in response, vid paragraphs 54 to 55 of their statement of defense, contended that the issues are subject of a pending suit and that they shall contend that the court lacks jurisdiction over claimant case and that same amounts to an abuse of the court process. Howbeit, I've resolved the issue of abuse of court process and jurisdiction earlier in this judgment. I adopt then for this part of the argument of parties. However, the defendants never specifically denied the averment of claimant that there was a court order on the 15th of March 2021 asking parties to maintain status quo, and the same was served on them. By the rule of pleadings, specific allegations of facts in the statement of claim or facts not specifically denied in the statement of defense are deemed admitted and requires no further proof. See the case of APC and Jega, the case of NRM and FC versus Johnson. It is thus not in dispute that the defendants were aware of the order of court. I so hold. I take cognizance of the fact that the defendants vid paragraph 2 of their amended statement of defense averred that claimant was expelled from the first defendant for his anti-union activities and insubordination. They relied on copies of query to claimant and the letter of expulsion respectively dated 8th of June 2021 and 6th of July 2021. It is therefore clear that the defendants are contending that the expulsion of the claimant was on the disciplinary issue. The said query is herein as Exhibit L, while the letter of expulsion is herein as Exhibit L1. It needs to be stated that the fundamental right to assemble and associate by forming or belonging to a trade union or any other voluntary association enshrined in Section 40 of the Constitution encompasses the right to dissociate or be dissociated with an association joined by termination of membership. Consequently, termination of membership will not ordinarily be an infringement of a right to associate. See Executive Chairman and Management of Benue, Subeb versus NASU. Allied to the above is the fact that ordinarily, the first defendant being a voluntary association has the right to discipline its members. As a voluntary association, it has the right to lay down its own decisions on discipline. The union is in its own right supreme over its own affairs. As such, the court will ordinarily not interfere with the discipline of a member of a voluntary association as that ordinarily falls within the association's internal affairs, and the court will not substitute its own will but that of any voluntary association. See the decision of the Apex Court in the case of Mbanefu and Moloku and others supra. However, the exercise of such powers of discipline cannot be done in a manner that interferes with the administration of justice. The defendants in their pleadings did not specifically deny the averment of claimant as to the defiance of a substituting court order in his removal. It is settled law that facts not specifically denied are deemed admitted as reason supra. It therefore means that as at when claimant was queried on the 8th of June 2021, vid exhibit L, and expelled on the 6th of July 2021, vid exhibit L1, there was a substituting court order of the 15th of March 2021 by the FCT High Court, urging parties to maintain status quo. The question that then arises is, can the defendants go ahead to discipline claimant by issuing exhibit L and L1 in view of the court order? It needs to be emphasized here that orders of court are meant to be obeyed and respected whether a party questions the validity or not, as long as the order of court is subsisting and has not been overturned by an appellate court and by any appellate court. See Cameron International Limited and Stabilini Visiononi, Abeke and Odonsi. Thus, anyone who is served with or becomes aware of an order of court should ensure that he obeys it in full, whether he feels it is right or wrong. The dignity and honor of our courts and the sanctity of our judicial process cannot be maintained if litigants are allowed to treat orders of court with disdain just because a party does not agree with it. A court frowns at disobedience of its orders or any order by a court of record. Where a party is aggrieved by an act of disobedience to an order of court, the court has power to set aside such acts done in disobedience to the order of court and return parties to the status quo before the order was made. The rationale for this is the enthronement of the rule of law rather than acquiesce in resort to self-help. CAPC and Carfi. In fact, it is the duty of every court to uphold obedience to an order of a court and not to encourage disobedience of a court order. Sincure Nigeria PLC versus Boles in Enterprise Nigeria Limited. It does not matter if it was not the court before whom the matter is heard that made the order disobeyed. The Apex Court in the case of Abeke and Odunsi Supra at pages 30 to 31, paragraphs H to A, held that it is not expedient that a contemnor of a court's order should be heard and obliged any favor either by the same court which he holds in contempt or any other court of law whatsoever, as he who comes to equity must come with clean hands. The Apex Court in the case of Jeff and Iyotom held that a person who is in disobedience of a subsisting court order are not entitled to exercise of court's discretion to enable him continue in defiance. See also Omie Kuna and Omie Kwana. The defendants who disobeyed the order of court asking them to maintain status quo cannot have this court protect their contemptuous act of going ahead to expel claimant. In fact, the Apex Court in the case of Umar and APC held that it is a very serious matter for anyone to flout a positive order of a court and proceed to taunt the court order by seeking a remedy in a higher court while still in contempt of the lower court. Thus, even if it is true that there is an appeal over the incidents at the High Court of FCT, it is irrelevant that the defendants have sought the remedy of the appellate court in this instance. They ought to first obey the order of the High Court of FCT, asking parties to maintain status quo. All I'm trying to say is that the first defendant, having exercised his right to discipline claimant in defiance of a subsisting court order, cannot be heard to say that the court does not have a right to interfere in this action. As such, both exhibits L and L1 cannot be made to stand. They were both actions taken by the defendants in blatant defiance of the order of court. The defendant thus acted ultra vires, consequent upon which I hold that both the query issued and the expulsion of claimant by CWC communicated to him via exhibit L and L1 were done unlawfully and thus declared null, void, and of no effect, and thus set aside for being in disobedience to a subsisting order of court. Accordingly, relief 8 in the statement of facts succeeds. The claimant in this action maintained that his suspension and removal as president of the first defendant were not in compliance with the provisions of the constitution of the first defendant, and that his removal as president was also done by NEC in defiance of the court order. It is in his position that the second defendant has no power to unilaterally, without recourse to him, requisition the meetings of the CWC, where the decisions that he should step aside as president while the third defendant takes over, the meetings of the NEC, where the decision of CWC above was ratified, and that the NEC could not deviate from the order of court asking the parties to maintain status quo to ratify the illegal resolution of the CWC, thereby removing him as president and appointing the third defendant in his stead. He also maintained that he was not given a notice of a meeting of the NEC where the decision to permanently remove him as president was taken. It is also his contention that he had not been adjudged a criminal to warrant the decision of the CWC asking him to step aside. The defendants, in response, be it the amended statement of defense, agreed that the second defendant has no power to unilaterally requisition a meeting of any of the organs of the first defendant without the president, but in the absence of the president, he could do so upon consultation with the third defendant, who was now the acting president. He also maintained that claimant could not be given notice of a said meeting owing to his absence, and such notice was no longer required as the third defendant was already acting in his place to prevent vacuum. Claimant in his response contended that only the National Delegates Conference could validly remove him as he was elected. Learned Defense Counsel submitted that claimant's pleading is not sufficient, as the claimant case is a complaint against second defendant's power to requisition meeting in the ordinary course of governance of the union, where consultation with him is required. He further submitted that insofar as the claimant did not by his pleadings challenge the emergency, especially powers of the second defendant as Secretary General to summon the emergency meeting of CWC and NEC, nor the quorum formed by the third defendant as vice president at that time, then there is no sufficient pleading to found a cause of action against the defendant. He also submitted, while relying on Rule 15 of the Union's Constitution, that the requirement of consultation with the president applies only in the ordinary or normal course of administration of the Union, and not during emergency, and what is required for a valid emergency meeting of the NEC is the president or vice president, a quorum of at least 50% of other members, while CWC is the president or vice president with other 6 members. The claimant did not plead, neither did he give evidence that there was no meeting of CWC or that there is no quorum of the meeting of each of the 2 organs. With respect to the evidence placed by the claimant before the court, counsel proceeded that from the implication of the fate of the consequential amended reply to the statement of defense, whatever evidence is built on or around the otherwise incompetent process is itself incompetent and inadmissible. Hence, claimant has failed to prove his case to warrant grant of the relief sought against the defendants in this case. He cited the case of Nongo and Achado. Learned claimant's counsel on his part submitted that the CWC is not empowered by the constitution of the first defendant to ask, direct, or mandate the claimant to step aside from its elected office. He placed his reliance on exhibits B1, B2, and B8, which is the constitution of the first defendant and the condition of service. According to counsel, it is only the NDC that elected the claimant that has powers to take any decision on matters involving the claimant or affecting his tenure as the national president of the first defendant, and not the CWC or the NEC. He ought the court to hold that the meeting of the members of the CWC of the first defendant was in violation of his constitution, and the resolution reached invalid, having been reached in excess of the authority conferred on the CWC by the first defendant's constitution. He cited in support the case of Oniga, government of Cross River State, and an order. It is in my respectful view that members of the first defendant, having agreed on their constitution, are bound by the letters and the spirit of same. There is no doubt that the members of the first defendant clearly intended to be bound by the said constitution, at least for orderliness. By Rule 15, 2, and 3 of the said constitution, herein as Exhibit B1, it stipulates thus, and I quote, just a minute, please. It stipulates thus, and I quote, National Executive Council. The meeting of the National Executive Council, NEC, shall be held once in a year, but emergency NEC shall be held as and when necessary. The venue of the meeting shall be determined by the Central Working Committee, of the National Executive Council, the president or a vice president, and at least 50% of other members shall constitute quorum. 3, Central Working Committee. The Central Working Committee shall meet 2 times a year, but emergency meetings shall be summoned as and when necessary. The president or a vice president and at least 50% of other members shall constitute quorum, unquote. Rule 14A2 of the same First Defendant's Constitution stipulates that the national president, quote, shall preside at all national or special emergency delegate conferences, meeting of the National Executive Council and the Central Working Committee, and shall be responsible for proper conduct of the business at all such meetings. He shall have a casting vote in case of a tie. The provision of the said rule above are unambiguous as to the requisitioning of a meeting. The law is settled that where the language of any statute or instrument or documents are clear and unambiguous, the court would not allow anyone to introduce or import extraneous words or matters into its interpretation, and the document must be interpreted as a whole to achieve its objectives, and which objectives are captured in Rule 2 thereof. On the face of the documents before the court, the claimant, who was supposed to preside over all meetings of the first defendant, was involved in a criminal allegation with NAPTIP. The doctrine of necessity, which is a common law doctrine, applies where some action is necessary to prevent a greater harm. The Canadian court, in the case of remuneration of judges of Provincial Court, PEI, citation captured, warned that the doctrine of necessity should not be applied mechanically because it is intrinsically unfair and preserves the unconstitutionality and sanctions unfairness. See also the decision in the Canadian case of Canada, Director of Military Prosecutions and Canada Office of the Chief Military Judge, citation captured, where the court found that the doctrine is not without its own limitations. This doctrine applies where the action taken is the only necessary thing to do in that wise, and there was no alternative given the situation. See the decision of the English court in the case of R. and Shelley, or Sheller, citation captured. The decision of the Supreme Court of Malawi in the case of Attorney General versus Masali SG, citation captured. The Supreme Court of India in the case of Maharashtra versus Dr. Praful B. Desai, citation provided. Thus, the doctrine is only invoked in cases of absolute necessity. See the decision of the Apex Court of India in the case of Election Commission of India versus Dr. Subramaniam Swamy, citation provided. In Nigeria, the doctrine has been applied in cases where a voluntary organization by necessity has to act outside its constitution where necessary. See Adroy Sim and others versus Eme and others, citation provided. By the evidence before this court as given by claimant, he was arrested on the 22nd of February 2021 by officers of NAPTIP and was in detention for 14 days under investigation for an alleged criminal allegation. According to claimant's uncontroverted evidence, it was while he was in detention that a meeting of the CWC was requisitioned by the second defendant without consulting him. In my view, there was no how the second defendant would be required to consult him before convening the meeting of the CWC on an organ of the first defendant to act in such situation of emergency. There was also no how claimant could be expected to be devoted to his duties as the president of the first defendant with such situation on his hands. The requisitioning of the meeting of the CWC and the actions taken by the committee that claimant should step aside as president until the criminal allegation he has with NAPTIP is resolved, while the third defendant, who was the vice president, acts in his stead as acting president, can be excused because his decision was aimed at preventing the union from having leadership crisis. The evidence elicited from DW1 under cross-examination that during his tenure, he had similar issue of dismissal from Taraba State Government Civil Service and was given the needed support by the association and still held on to his position as president is irrelevant. The union acting through the CWC cannot be compelled to act in a particular way. That is within their internal affairs, even when unreasonable. The requisition of the meeting of the CWC while claimant was in detention and the actions taken by the committee that claimant should step aside as president in view of the allegation for a criminal offense for third defendant to act in his place till the issue is resolved, viz. Exhibit L8, was a reasonable thing to do in the circumstances of this case, since claimant was under investigation for a criminal allegation which could land the first defendant into leadership crisis. Accordingly, reliefs 4 and 5 fail. In spite of the above, it is the law that documents speak for itself and will not speak through witnesses. See Ngere and Okureket. Number 14. Ayorinde and Kuforiji, Olowo and Building Stock Limited. It is clear from Exhibit L8 that the third defendant was only to act till claimant resolves his issues with NAPTIP. In fact, at page 24 thereof, the third defendant himself stated that once claimant was free from his ordeal, he will when claimant is free from his ordeal, he will resume his functions as the national president of the first defendant. It is also clear from Exhibit L8 at page 25 thereof that it was agreed that a NEC meeting be held on the 16th of March 2021 for ratification of the decision of CWC therein. The above does not, however, mean that it will be the same for NEC meeting, which was held later. The NEC purporting to ratify the decision of CWC by the unchallenged evidence of claimant defiled the order of court made on 15th of March 2021 that parties should maintain status quo as status supra. It also reached a final decision to permanently remove claimant from his position as president by ratifying the decision of CWC without inviting the claimant before the said CWC to afford him fair hearing now that he was out of detention. In purporting to ratify the decision of CWC, the NEC not only committed contempt of court, but also shaved the claimant's head in his absence by breaching his right to fair hearing, even when a member of the said CWC, one comrade, Duanana, had advised at page 23 of Exhibit L8 that a 3-man committee be set up to contact claimant in order to hear his side of the story. All I'm saying here is that the NEC ought not to have sat in view of the subsisting order of court. Also, although claimant could not attend the CWC meeting, which he is ordinarily a member by Rule 14A2 of the Constitution because same was requisitioned while he was in detention, he ought to have been invited to the NEC meeting since by then he was out of detention, especially in the spirit of fair hearing, in order to hear his side of the story before any permanent decision removing him will be taken. This is even the position of the Creator, God, when in spite of the knowledge that Adam and Eve had disobeyed him by eating the forbidden fruit, he gave them the opportunity to state their own side of the story. See Genesis 3, 9-13. The NEC of the first defendant should not have defied court order to remove claimant in breach of his right to fair hearing. They ought to have maintained status quo as ordered by the court, which was that claimant was and still the president, but that the third defendant only acted in his place as acting president until the issue claimant had was resolved. More so, it is a principle of law that the presumption of innocence is in favor of a person alleged of a criminal offense in this crime until proven guilty as reasoned earlier. This alone should have restrained the NEC from even taking any decision on the issue to claimant his charge in court and trial concluded. He was expelled via Exhibit L1 before he and co-defendants were arraigned on the 7th of July 2021 before a High Court of FCT. It is evident in Exhibit L8, the minutes of the emergency meeting of the CWC on the 9th of March 2021, that some members of the executive of the first defendant had prejudged the claimant by their comments without hearing his own side of the story. Ordinarily, the doctrine of ultra vires has no application in the internal affairs of the voluntary association according to the Apex Court in the case of Agama and APC. The above is no doubt the general rule, which, like most legal rules, admits some exceptions, especially where there is a breach of a right of fair hearing in its decision or even defiance to a subsisting order of court, which must be obeyed notwithstanding the disposition of parties or the right of the first defendant over his internal affairs. See the case of Ogboro and registered trustees of Lagos Polo Club and another. It is in view of all the above that I find that a purported removal of claimant as the substantive president of the first defendant by NEC is ultra vires, unlawful, and thus set aside. I do not lose sight of the contention between parties as regards whether or not the third defendant's retirement from the civil service affects his position in the first defendant office and is no longer a member of the first defendant. The claimant, by paragraph 89 of his statement of facts, averred that the third defendant is retired and is not qualified to hold position in the first defendant. The defendant, by paragraphs 25 to 26 of their amended statement of defense, averred that the third defendant holds tenured appointment, which does not expire by retirement from service, and that by precedent, persons who have retired continue to hold elective posts. Claimant, on his own part, in his amended reply, averred that the third defendant, having retired from service, cannot validly conduct the affairs of the first defendant or act in the capacity of national president, and contended that the first defendant does not practice tenured appointment by which national president who are no longer in service remain in office as same was not provided in the Constitution. It is thus not in dispute that the third defendant has retired. The only contention between parties is whether the third defendant can continue to hold elective posts in the first defendant. I am of the respectful view that whether or not the first defendant, by virtue of his retirement, can continue to hold elective position in the first defendant is an internal affairs of the union, which does not concern this court. The third defendant was originally elected as vice president before he started acting in place of claimant, and his office is protected under the provision of Rule 14B of the Constitution. If he retires and is no longer a civil servant, but the first defendant allows him to continue to hold the elected post, it is not the business of this court, especially as he was elected. Besides, by the evidence of CW2 under cross-examination on the 14th of March 2024, as an elected national treasurer of the first defendant, even when he retired, he still stayed in the first defendant till he finished his tenure as national treasurer before he finally left the first defendant. Also, by the uncontroverted evidence of DW1 under cross-examination by Learned Claimant Counsel, revealed that even while he was president and was during his tenure dismissed by Taraba state government, he still continued as president. Thus, there was precedent for such. The court in this case finds that where there is precedent for such situation as capture supra, it will not substitute its own will for that of the union. If the union still retains the third defendant even after his retirement, then so be it. However, it must be stated that the will of the first defendant to retain the third defendant in his elective post as the vice president even after his retirement cannot be done in a way that breaches the contractual right of claimant or in a way that affects his personal right, especially since he was validly elected on a 4-year tenure as president, which is still running and yet to expire. All I'm saying here is that the third defendant cannot continue to act in place of claimant as the elected president of the first defendant, though he can retain his own position as the vice president if the union wishes. I say so in view of the fact that the third defendant, even by his own admission in Exhibit L8, as reason supra, admitted that he was only to so act until claimant is cleared of the allegation against him by NAPTIP. Claimant has been acquitted of the allegations made against him by NAPTIP since 18th of April 2023, vid Exhibit B16 on record of this court. And the allegation was what instigated the issues which led to the dispute in this case. By the uncontroverted evidence before the court from both parties, Claimant's tenure as elected president for a 4-year term began on 29th of July 2020 and not to expire on 29th day of July 2024. Claimant has been cleared by the court since 18th of March 2023, and this is 2024, but claimant was still held out of his position as the president of the first defendant. Why then are they still yet to restore the claimant to his position as president, even after he was discharged and acquitted by the court? In my view, from the 18th day of April 2023, when claimant was cleared, the first defendant ought to return him back to his position, while the third defendant steps aside and back to his original position as vice president, since he himself, by the documentary evidence at page 24 of Exhibit L8, agreed that it was only to act till claimant was cleared of the allegation against him. See paragraphs 0402 to 0408 of Exhibit L8. In view of all the reasoning above, I hold that release 1, 2, 3, 6, 7, 10, 11, and 12, the statement of facts succeed, while relief 9 thereof fails only to the extent that the third defendant, who is an elected vice president of the union, may be allowed by the union to complete his tenure as the vice president. Claimant by relief 13 is claiming costs incurred in this action, which he assessed at 3 million naira. The Supreme Court in this line of cases, the case of Nongwa and Achado and others, Ubani and Ukoma and another, versus 7-Up Bottling Company PLC and another, First Bank and Oronsanye, held that a successful litigant is entitled to costs which he should not be denied except he misconducts himself. In the same vein, the same court in Mekuya and Emirates Airlines, per order GSC now retired, held that costs, including costs of litigation, is at the discretion of the court, once empowered by its rules, and the Court of Appeal in that case was wrong to have held that the award of costs in that case amounted to granting special damages not proved. Thus, it means that cause of action may be granted even where not proved, provided the court is empowered by its rules to grant same. This court has similar provisions as it is in that case, as that of the Federal High Court relied upon, considered by the Supreme Court in the case of Mekuya Supra. The NIC Civil Procedural Rules, particularly Order 55, empowers this court to grant cause of action as its own discretion. The discretionary power of the court is to be exercised judicially and judiciously. Claimant in this case, including his counsel, were in court most times of the proceedings. Neither did he misbehave or misconducted himself throughout the proceeding. It is in the light of this that I exercise my discretion in awarding the sum of 3 million naira claimed as cost against the defendants jointly. I so award. The court has inherent power to make consequential orders that will give life to declarations made. A consequential order is simply one which flows directly and naturally from the decision or order made on issues litigated upon and inevitably consequent upon it. See Onyadi Development Nigeria Limited versus Kuta and others. The case of Nokwa and Executive Governor of Plateau State and others. I've held that claimant is still the substantive precedent of the first defendant in the eyes of the law, by discharge and acquittal by the court criminal case. He ought to have been restored to his position as the substantive president of the first defendant since 18th of April 2023, when he was acquitted in view of the fact that by Exhibit L8, the third defendant was only to act in his stead till he is cleared, especially as it was an elected post to enable him complete the mandate of members of the union who elected him. Please mute your phone. Please mute your phone. God's power, happiness. Mute your phone. Claimant would not have been asked to step aside if not for the allegation against him, and which allegations he had been acquitted of. Having declared the actions of the CWC and NEC unlawful, illegal, null and void and of no effect, and accordingly set same aside, it is in consequence of the above that I make an order reinstating the claimant back to his post as the substantive national president of the first defendant and be accorded all the incidents and benefits of his office till when his tenure will be lawfully completed. In sum, and for the avoidance of doubt, I declare an order as follows. 1, the claimant is still the lawful and substantive national president of the first defendant, and thus the defendants, their agents or privies are hereby restrained from treating claimant otherwise until he finishes his 4-year tenure. 2, the expulsion of claimant from the first defendant is nullified. 3, the claimant is to be reinstated to his position as national president of the first defendant with effect from April 2023 and accorded all the benefits and incidents of office from then to when he will lawfully complete his tenure on July 29th, 2024. Reliefs 1, 2, 3, 7, 8, 10, 11, and 12. The statement of facts succeed, while relief 4, 5, 6, and 9 thereof fail. 5, claimant is entitled to cost of 3 million naira as cost against the defendants jointly. And 6, this judgment is to be complied with forthwith, failing which the judgment sum shall attract 10% post-judgment interest. Judgment is accordingly entered. For parties are entitled to have clean copies, which you can pick tomorrow from the court. I have another matter. Court registrar. Court registrar. Court registrar.
It is only proper.
Very well. Court registrar. Are you online? Are you online, court registrar? Court registrar, are you online? Court registrar. No, thank you. Thank you. Our counsel to the second case, are you online? Let me check your names. Are you online? The case of Balasali and 115 others.
Yes, my lord. The claimant is represented, my lord.
Okay, very well. How about the defense counsel?
Yes, my lord. We're online, my lord.
Oh, yeah, very well. My court registrar is saying that he's having problem joining back, that they are saying the host cannot invite him. So I want him to quickly correct that, and then I'll proceed with the judgment. Kindly give
Okay,
him
my
some
lord.
that he can call the case.
Okay, my lord.
As a court, please. Yes, my lord.
Thank you. Just a few minutes, please.
Hello.
Registrar, are you now online? Registrar.
Yes, my lord.
Okay, so call the case. Call the second case.
Case number NICN/ABJ/261/2022 between Balasali and 116 other and British American Tobacco Nigeria Limited. 2. Professor Peter Ocheme.
Very well. Any of the parties in court?
The claimants are absent, my lord.
Okay. Defendant? Any of the
is also absent.
okay, so parties absent. Appearances.
May it please this honorable court.
Yes.
My name is Daphne Edugele. Daphne is spelled D-A-P-H-N-E. Edugele is spelled, my lord?
Go ahead, Daphne.
It's spelled D-A-P-H-N-E.
I know Daphne, but Edugele.
Edugele is spelled E-D.
I can see it.
Yes, my lord.
Very
Holding
well.
the brief of A.O. Omole.
For
the claimant, my lord.
Very
A.O.
well.
Omole sent his sincere apologies for his absences, otherwise engaged in other matters before the Supreme Court, my lord. He really
Very well. Any other appearance? Any other appearance?
Yes, my lord. Yes, my lord. May it please, my lord. Olujoke Aliu. My lord, Aliu is spelled without a Y. My lord, I appear for the first defendant.
Kneel for the second.
Kneel for the second.
Very well. Here's the judgment of the court. By a general form of complaint dated 27th of September 2021, the claimant commenced this suit on the 1st of April 2022 and further amended general form of complaint they filed claiming against the defendants as follows. 1. A declaration that the claimants as employees of Nigeria Tobacco Company PLC, now British American Tobacco Nigeria Limited, by virtue of a merger in 2000, are entitled to a full refund of their monies respectively contributed to the first defendant staff provident fund, together with all sums accruing as interest, returns, or howsoever described as previously administered by the defunct Nigeria Tobacco Provident Trust Fund Company Limited or its successor in title. 2. A declaration that the purported terms of settlement dated 4th February 1998, entered and executed by the second defendant purportedly on behalf of the first to seventh claimant, with the first defendant then known as Nigerian Tobacco Company PLC, NTC, by which the second defendant considered to lesser sums than the claimants were otherwise entitled to without the claimant's prior knowledge or consent is void. 3. An order of this Honorable Court nullifying and setting aside the purported terms of settlement dated 4th February 1998, entered into and executed by the second defendant purported on behalf of the first to 70th claimants in the first defendant then as NTC, including any actions or steps taken by the second defendant purportedly on claimant's behalf, furtherance or pursuance of the said terms of settlement for lack of requisite consent. 4. An order of this Honorable Court entering judgment in favor of the claimants and against the defendants jointly and severally in the sum of 1,391,404,545 naira 48 kobo, being the aggregate contribution standing to the credit of the claimant as principal from their staff contributions into the staff provident fund over the course of their respective employment, comprising employees, 7% contribution, which they put at 612,313,500 naira 4 kobo, and their 10% contribution they put at 779,091,045 naira 45 kobo, which was then administered by the first defendant through its defunct Nigeria Tobacco Provident Fund Company Limited. 5. An order of the Honorable Court awarding interest on the claimant's aggregate principal contribution in relief number 4 above in the sum of 535,092,177 naira 14 kobo at the prevailing Central Bank of Nigeria minimum rediscount rate from the sundry dates of the claimant's contribution to 31st of August 2021 as shown in the schedule of accounts annexed thereto, and such further subsequent prevailing CBN MRR interest rate until date of delivery of judgment therein. And 6, an order awarding post-judgment interest on the aggregate sum adjudged due in reliefs 4 and 5 above at the rate of 10% per annum until full satisfaction of the judgment. And 7, cause of this action. It is the case of the state claimants that they are retired staff of the defunct Nigeria Tobacco Company, that's NTC, and that the first defendant became NTC's successor in title, vested by the operation of law. They went on to state that by virtue of the terms of their engagement and not being management staff, they are not entitled to pension after retirement. However, they are entitled to benefits under Nigerian Tobacco Provident Fund warehoused with the Nigerian Tobacco Provident Fund Trust Company Limited, wherein each staff contributed 7% of their monthly salary, while NTC on its part contributed 10% of the earnings of each employee into the fund on a monthly basis. According to the claimants, upon their exit from the employment of NTC, they made several demands for their entitlements accruing from their contributions under the funds, but same were ignored. That following the failure of the first defendant, formerly NTC, to pay their terminal entitlements despite their repeated demands, they retained the service of the second defendant in 1997 to take steps to recover their monies from the first defendant, including taking out legal proceedings against the first defendant on their behalf. That in furtherance to the above, they jointly and severally instituted various proceedings against NTC, first defendant predecessor in title, and others before the Kaduna State High Court, Zaria Division, in 4 separate lawsuits, where the first defendant elected to settle out of court. However, claimants were not part of the negotiations, and the compromise that followed, despite their protests and requests to be involved in the settlement process, and that they subsequently realized that the first and second defendants went ahead to sign purported terms of settlement on their behalf without their knowledge, authority, or consent. Continuing, the claimants aggrieved with the first defendant's persistent refusal to pay them their entitlement, they instituted an action in 1999 and 2000 before Kaduna State High Court, Zaria Division, to recover their entitlements Similarly, upon an interlocutory ruling of the court, setting aside the issuance and the service of a writ of summons on the first defendant on both actions, claimant filed 2 separate appeals to the Court of Appeal. The appeal were allowed. The Court of Appeal made an order that the cases be tried at the lower court by a different judge. And at the time of delivering the said judgment, the Kaduna State High Court no longer had jurisdiction to entertain the claims of the claimant against the defendant by reason of amendment of the Constitution of the Federal Republic of Nigeria, 3rd Alteration Act 2010, which vests exclusive jurisdiction over employment and labor-related matters in this court. Hence this action, the institution of this suit before this court. The first defendant in opposition filed notice of preliminary objection, challenging the jurisdiction of this court to entertain this case, and not the court to dismiss same on the basis that it is statute barred. The grounds upon which the application is brought are that the claimant respondent cause of action in respect of the reliefs contained in the statement of facts are based on the claim that they are entitled upon retirement, resignation, or dismissal to aggregate entitlements in the Nigerian Tobacco Provident Fund Trust Company. 2, the claimant complains that they were not carried along in the settlement discussion between the predecessor entitled of the first defendant, the second defendant, sometimes as far back as September 1997, and the entitlement remained unpaid by the first defendant. 3, to the extent that the claimant's relief is an attempt to recover funds which were due at the time of their retirement, termination, or dismissal prior to September 1997, such claims are barred by Section 7A of the Limitation Act, Cap 522, Laws of Federation 2004, which prescribes a 6-year limitation period of action founded on contract. Also, filed along with the notice of preliminary objection is a written address. I have captured basic part of it into the judgment, and also the first defendant in response, the claimant also filed a reaction to it. The claimant, just a minute. Trial commenced and was concluded. I want to go straight to the decision of the court. I've captured all the salient part of it, including counsel submission in their written addresses. So I'll go straight to the decision of the court. I'll peruse the originating processes. The amended complaint together with the accompanying processes, including the amended statement of facts, amended statement of defense, along with accompanying processes. The reply on point of law filed by the parties to the notice of preliminary objection, as well as the notice of preliminary objection as I've stated. I'm of the view that the issue that will best determine this case are as follows. 1, whether the claimant's action is competent before the court to invoke the jurisdiction of the court over the matter, and if answered in the affirmative. 2, whether claimants are entitled to relief sought. It is the position of the first defendant that by the Limitation Act of FCT, claimant's action is statute barred, since their cause of action arose way back after the exited employment of the first defendant and is brought outside 6 years because their cause of action arose with the latest claim in 1995, while this action was instituted in 2021. It relied on Section 7 of Limitation Act of FCT. The above position no doubt touches on the jurisdiction of this court to entertain this action. Now, addressing the above issue, I must first say that the jurisdiction is the bedrock of an action. Thus, the court must be shown to have jurisdiction before entertaining an action, failure of which any decision taken will be an exercise in futility. See the case of Barnes Engineering Company Nigeria Limited and Government of Rivers State, COP Anambra State and another, and AA Omohai International Limited, Indul and Wayo and others, citation captured. Jessica Enterprise Limited and another versus Leventis Technical Company Limited, citation provided. Just a minute. I bear in mind the submission of learned senior counsel for the first defendant in his final written address that the court should not rely on the case of National Revenue Mobilization and Fiscal Commissioner Ajibola Supra and the more recent case of Obasanjo and Wuruboga on the ground that the decisions of the court in those cases relate to the Public Officers Protection Act. I also bear in mind the submission of learned claimant counsel on the above argument of the first defendant, wherein he submitted in his final address that the argument is misconceived and should be discountenanced, while urging the court to be persuaded by the decision of this court by my learned brother judges, non-reported suit number NICN/LA/553/2018, the case of Mr. Godwin Kechukwu Nkome versus First Bank Nigeria Limited. There's no doubt that decisions in cases are only authorities for what they actually decide. See Udo and the State, the case of Ogwanyi and Nikon Insurance Limited, Western Steelworks Limited, and Iron and Industries Steelworkers Union of Nigeria and others. The decision of the Apex Court in the case of Mobilization and Fiscal Commission versus Ajibola Johnson and others Supra, and the more recent case of Obasanjo and Wuruboga Nigeria Limited Supra are to the effect that the period of limitation in the Public Officers Protection Act does not apply to cases founded on contract. The decisions have nothing to do with the Limitation Act of FCT, under which Learned Defense Counsel is making his submission. Thus, the court cannot rely on those cases. Notwithstanding the above, it is expedient for the court to resolve the issue of its jurisdiction above, as it relates to whether the claimant's action is statute barred. This court is thus clothed with substantive jurisdiction over this action, but which jurisdiction may be lost by virtue of the limitation period in the Limitation Act of FCT. Section 7(1)(a) of the Limitation Act of the FCT, makes provision that actions founded on simple contract shall not be brought 6 years after the cause of action arose. It is thus clear from the provision of Section 7 that actions founded on simple contracts are statute barred after 6 years in the FCT. The pertinent question to be asked at this stage is, can claimant's action be said to be one founded on simple contract? I'll proceed to answer this question now. The Apex Court in the case of Edison Automotive Industries versus Nefon Supra, per Joru GSC held that a simple contract is all contracts other than formal contracts or contracts required to be under seal. See also Sage Nigerian Law of Contract Spectrum Law Series, 2nd edition, published by Sweet and Maswell at page 4. It is thus clear that formal contracts are not simple contracts. The Court of Appeal, per Muhammad Danjuma JCA in the case of Adeni and Governing Council Yaba College of Technology Supra, held that such employment contracts are formal contracts when it held entirely those. Now, quote, now what is simple contract? The answer to this question will throw open the answer as to what genre of contracts are not simple contracts and which would therefore be covered by the said limitation law. Sagi SAN in his book Nigeria Law of Contract Spectrum Law Series 2nd edition, Sweet and Maswell, page 4, defines simple contract as all contracts other than formal contracts or contracts required to be under seal, unquote. The appellant's contract of employment was not one required to be under seal. Was it a formal contract then? I think it was. The employment of the appellant in an established institution, no doubt, is a formal contract governed by terms and conditions binding between the parties, unquote. Flowing from the above decision, there is no doubt that claimant's employment is an established institution, that the first defendant, and which employment is governed by Exhibit A1 being the condition of service, and which contracts were severed by different formal documents contained in Exhibit A, are formal contracts. The first defendant in its reply address has submitted that the decision in Adeni and Governing Council Yaba College of Yaba College of Tech Supra is not applicable herein, as the employment contract therein was on statutory flavor and not one of master servant. Let me say that the decision in Adeni's case above is clear, and the basis of the decision of the Court of Appeal above, that the employment contract was a formal contract, had nothing to do with whether it was master servant or statutory, as the counsel tried to distinguish. The court was clear when it said employment of the appellant therein in an established institution, no doubt is a formal contract governed by terms and conditions binding between the parties. Therefore, it is clear from the above decision that employment in an established institution, which is governed by terms and conditions binding between parties, is formal contract. In the instant case as reasoned supra, Exhibit A and A1 contain the terms and conditions of employment of the claimants, including the terms of the severance of the employment relationship that once existed, and which terms no doubt are binding on parties, and thus make the employment contract between parties a formal one and not a simple contract. In the same vein, learned counsel for the first defendant, also in paragraph 14 of his reply address, refer this court to an unreported decision of this court delivered by my learned brother to the effect that employment contracts are simple contracts. The position of the law has not changed, that cases are determined based on their peculiar facts and circumstances, and as such, a counsel who wants the court to rely on the case as an authority has the duty to properly cite a case, and where unreported, a certified true copy of the judgment must be placed before the court, so the court can have a clear view of the background facts of the case leading to the said decision. See the case of Chidoke and another and First City Finance Limited, the case of Ugudo and the state. Learned First Defense Counsel cannot attempt to belabor the court by merely citing and discharging the burden by putting the website address of the court where the case can be assessed without clear reference as to the date the said decision was delivered, as there must have been countless judgments delivered by my learned brother on the said website, and only the date of delivery of judgment will streamline the search. All I'm trying to say is that merely citing an unreported case without important particulars like the date of delivery of a said decision and directing the court to its website does not discharge the burden placed on counsel to place a certified true copy of the unreported judgment relied on before the court. In any case, the said decision referred to is not binding on this court, but only persuasive, especially in this instance, where the facts of the said leading to the decision case are not before the court. By the combined effect of the above decision in the case of Edition Automotive Limited and F1 Supra, and Adeni and Governing Council Yaba College of Technology Supra, and the content of Exhibits A and A1, the claimant's employment being formal contracts, cannot then be said to be a simple contract. In fact, in my own view, employment contracts are formal contracts that are sui generis, that is, in the class of their own. They are not simple contracts. Thus, the period of limitation as regards simple contract will not apply to the case of claimants, which is founded on employment contract, which is a sui generis kind of formal contract. It therefore means that the action of the claimants cannot be properly situated under Section 7 of the Limitation Act of FCT, as the first defendant would want this court to so hold, to do. Assuming, but I'm not conceding, so the fact that claimants' employment contracts are even simple contracts, which are statute barred by the provision of Section 7(1)(a) of the FCT Limitation Act. I do not think same will apply to the case of the claimants. I'll proceed to explain why I said so. It is a cardinal principle of interpretation that statutory provisions must be interpreted in a holistic way to achieve harmony among its parts, especially by the provision dealing with the same subject matter, so as to give true intention to the lawmakers. See the cases of Kazim and Adese Mowo and others, Ghana and SDP and others, Wogu and another versus Chukwu and others. It must be noted that what claimants seek in this case are declaratory and injunctive reliefs. It is worthy of note that Section 12(1) of the Limitation Act of FCT provides that Section 7, 8, and 10 of the Act shall not apply to a claim for specific performance of contract or for an injunction or other equitable relief, including declaratory reliefs. It means that Section 7 of the Limitation Act of FCT cannot be read in isolation of Section 12 of the same law. The effect of this is that equitable reliefs must be an exception to the rule in Section 7 that actions founded on simple contract must be instituted within 6 years of the accrual of the cause of action. Declaratory reliefs and injunctive reliefs are no doubt equitable reliefs. See the cases of Enkine and West, CFAS Nigeria Limited and MIG4 Nigeria Limited, the case of Ogolo and Ogolo, By the decision of the Apex Court in CFAS Nigeria Limited and before Supra, the court, while relying on Section 13.1 of the Limitation Law of Lagos State, which is in pari material with Section 12.1 of the Limitation Act of FCT, held that equitable remedies or reliefs are not caught by the period of limitation. In Section 8 of the Limitation Law of Lagos State, which is also similar with Section 7 of the Limitation Act of FCT, the court emphatically quoted with approval the decision of a court of appeal. In that case, that an examination of the prayers or reliefs in the writ of summons and the statement of claim show that the basis on which the respondent action is supported in the joint venture agreement for the bidding for and subsequent management of Terminal C and declaratory reliefs had been held to be equitable, specific performance injunction, implied or constructive trustee recovery of trust property, fraud and fraudulent breach of trust, account and damages for conspiracy to injure and defraud, which are equitable, and therefore those reliefs cannot be termed simple contract as envisaged by Section 8.1 of the Limitation Law. Put differently, the statutory provision of 6 years for the accrual of the cause of action would not apply in this case. In the instant case, claimant has sought declaratory reliefs and injunctive orders, which are equitable reliefs and are exempted from the application of Section 7 of the Limitation Act of FCT. At any rate, even if the claimant's case is one founded on simple contract, as I've stated earlier, it must be pointed out that what the Limitation Act of FCT bears is the action and not the cause of action. And this is often misunderstood. Whereas the cause of action refers to the facts or combination of facts which the claimant must adduce to be entitled to any relief, the action itself is the medium through which the claimant ventilates his grievance through those bundles of facts called cause of action. In other words, thus, whereas the claimant cause of action remains intact, although in a vacuous and statute of limitation denies him of his right of action due to laches or undue delay in pursuing the action, the question then is, can the claimant be said to have unduly delayed in filing their action within 6 years, assuming their contract of employment even fall within the ambit of simple contract, which fact is not considered? I'll proceed to address this issue. It is important at this stage to determine when the cause of action of the claimant arose or accrued in order to determine whether the action is statute barred to take away their right of action. According to the first defendant, the cause of action of each of the claimants arose when each left the employment of the first defendant. Generally, a court in determining whether an action is statute barred is only to consider the originating process and the statement of claim, which is called the statement of facts here. See the case of Duzu and Yunusa, Hassan and Aliyu, Aremotu and Adepoyi, Egbe and Adefarasi. However, just like most legal principles, the above position of the law is not without its own limitation. It is a certain position of the law that where the court considers the issue of jurisdiction, especially as to whether an action is statute barred at the final stage of judgment, the court should not ignore other pieces of evidence in the case that may resolve the issue of jurisdiction or whether the action is statute barred, and must not pretend that those pieces of evidence do not exist, as doing so will violate the fundamental principle of fair hearing that requires the court to consider evidence on an issue and determine the issue before it. See the case of Abdullahi and Loko and others, Wali and APC and Larry. In the instance suit, the claimants are ex-employees of the defunct NTC, which was taken over by the first defendant. It is also clear from Exhibit A1 that some of the claimants have left the employment of the defendant long ago, as far back as the 1970s. If the court goes by the position of the claimants, is even founded on simple contract, and which means that the entitlement they are claiming here will be simple debt. The cause of action for recovery of such entitlement will not accrue when each of the claimants left the employment of the Nigerian Tobacco. In my view, being simple debt will accrue when the first defendant refused to pay after a demand has been made by the claimants. See Amedi and UBA, Kolo and FBN, UBN and Oki. The claimant, by the uncontroverted averments in paragraphs 8 and 9 of the amended statement of fact, averred that they gave the first defendant several demand letters demanding for their entitlements before going to court in 1997, and gave the first defendant notice to produce the said demand letters, which the first defendant failed to produce. Claimants still have onus to place at least secondary evidence of the demand letters before this court, notwithstanding the notice to produce, since service of notice to produce will not obviate burden on secondary evidence of the documents relied on. As such, it is irrelevant to serve notice to produce when the party serving it does not even have secondary evidence of same. C. Abimbola and the state, Emeka and Chuba Ipiazu, Nweke and the state, Buhari and another, Obasanjo and others. Assuming the court agrees that the case of the claimant is one founded on simple contract as proceeded by the first defendant, making their case one of recovery of simple debt, it is when the demands were made by the claimants that the first defendant and the first defendant refused to pay that the cause of action of the claimants will accrue as simple debt, and not when each of the claimants left the employment of the first defendant, as the first defendant would want this court to hold. In any case, I found that the case of the claimant is not one founded on simple contract, and I maintain that stand. In any case, there are other circumstances in this case that may determine whether the claimant cause of action is statute barred or not. From the fact of this case, that some claimants are supported by Exhibit A6 had instituted several actions before different courts and from 1997 to 2000. Specifically, the claimants jointly and severally first filed their actions in 1997. According to the first defendant, the said actions filed in 1997 culminated in a valid terms of state settlement, following an attempt at out-of-court settlement as shown by Exhibit A4. I'm mindful of the settled position of the law to the effect that negotiations or exchange of correspondence between parties will not affect the period of limitation or stop it from running. Sioko and others is A.G. Ebonyi. The case of Enemua and another versus Ezionye and others. The case of SPDCN Limited versus Ejebu. The case of Eboigbe and NMPC. However, the above position of the law is not absolute, as it has its own exceptions. The exception is also found in the decision of Adiojeasi in the above cited case Supra, to the effect that if the negotiation does not result in a settlement or in an admission of liability, the law will not allow the time devoted to negotiation to be excluded from the period which should be taken into consideration for the determination of a question whether a claim has been statute barred. Put differently, time will stop running when there is a settlement or an admission of liability, and all that remains is fulfillment of the agreement. It cannot be just and equitable that the action will be barred after the statutory period of limitation giving rise to the action if the defendant were to resile from the agreement during negotiation. See the cases of Frontera Petroleum Resources Incorporated versus NDIC, ABBA and the Board of Directors, NIPOS and another. I do not lose sight of the contention of the claimants that they did not agree or gave the second defendant the go-ahead as per the terms in Exhibit A4, and which contention I will address later in this case. One fact stands clear from Exhibit A4, and which is that the Nigerian Tobacco Company, which the first defendant represented, reached settlement with first to 70th Claimants Council in the previous suit filed before the year 2000. In fact, the first defendant in its amended statement of defense made an admission that the said terms of settlement, it is made an, sorry, I'll take this again. They filed if they are amended. In fact, the first defendant in its amended statement of defense made an admission about the said statement of defense. Sorry, about the fact that they filed the terms of settlement. It is the same defendant who, by his statement of defense, had admitted that there were terms of settlement reached by parties in 1998, who wants this court to reckon with the date of accrual of cause of action of all the claimants to the date they left employment. If the court agrees with the position of the first defendant that terms of settlement in Exhibit A4, which claimants are seeking to set aside, is valid, then it means that for those claimants in the said terms of settlement, their claims have all been crystallized to the same date as the said alleged statement will be the new compromise determining the claims of those claimants. That is, 1st, 2nd, 4th to 17th, 19 to 25, 27 to 71 claimants. All I'm saying is that the first defendant who is saying there were valid terms of settlement reached by parties in the year 1998, which in my view determines the new date of compromise, which will now be reckoned with the computation of time, cannot in another breath be saying that the said terms of the cause of action of the claimants, including those concerned by the said terms, accrued at the date they left employment. If the court accedes the request of the first defendant that the terms of the settlement are valid, then it is the date on the said terms that will be reckoned with in the computation of time, and not the dates the concerned claimants left the employment of the first defendant, as the terms of a settlement birth new compromise. On the flip side, by the uncontroverted facts averred by the claimants in the amended statement of facts, circumstances surrounding the disputed terms of settlement, which involve some of the claimants as stated, the filing of other subsequent suit for their alleged entitlement in the year 20 against persons including the first and second defendant herein, who were also defendant before the Kaduna State High Court in suit numbers KDH/Z/31/1999 and KDH/Z/48/2000, and to which suit all the claimants in this case were parties as shown by exhibits A6 and A7. Thus, while the suit involving the terms of settlement involve only the 1st, 2nd, 4th, 17, 19, 25, 27th to 21st to 71st claimants, the above two suits filed in the year 2000 had all the claimants as parties. The claimant in this case, even after the terms of settlement in Exhibit A4, were still claiming that their terminal benefits have remained unpaid since they left employment, which led to the above suit in the year 2000. The position of the law is clear that there are exceptions to the application of a limitation law, like the Limitation Act. One of such exceptions is in case of continuance of damage. In my view, a claim on arrears or unpaid terminal benefits is one of continuance of damage. I place reliance on the case of Raji and Minister, Federal Ministry of Education and others, wherein the court held inter alia that the failure to pay the employees their entitlement is inexcusable, as it is an act of bad faith and a continuous injury which falls into the exception to limitation period. In my view, for every month that the terminal benefits of the claimants remain unpaid after they left employment till when they all went to court in their previous suit in the year 2000, there was fresh cause of action. What then is the status of the case at hand before this court, now having been filed in the year 2021? First, let me say that on the authority of a notorious case of CFAS Nigeria Limited and others and McFoy, Supra, there may be instances where time will pause in the computation of period of limitation. It is worthy of note that the above two suits filed in the year 2000 gave birth to a ruling, as shown by Exhibit A6, which culminated into two appeals, on which the Court of Appeal delivered judgments on 26th of March 2020, which allowed the appeal of the claimants in the above suit and ordered that the matters be reverted back to the trial court, being the Kaduna State High Court. However, as of 2020, when the Court of Appeal delivered the judgment in Exhibit A7, the Kaduna State High Court, which was a trial court, no longer had jurisdiction by virtue of the Third Alteration Act 2010, which created this court and gave it exclusive jurisdiction in respect of labor matters. For the avoidance of doubt, Section 254C1 of the Constitution of the Constitution provides thus, and I quote, notwithstanding the provision of sections 251, 257, 272, and anything contained in this Constitution, and in addition to such other jurisdiction as may be conferred upon it by an act of the National Assembly, the National Industrial Court shall have an exercise jurisdiction to the exclusion of any other court in civil causes and matters, K, relating to or connected with dispute arising from payment or non-payment of salaries, wages, pensions, gratuities, allowances, benefits, and any other entitlement of any employee, worker, political or public office holder or judicial officer or any civil or public servants in any part of the Federation and matters incidental thereto, unquote. The above necessitated the refiling of this suit before this court. I am of the respectful view that time has been frozen or suspended from when they filed their action before Kaduna State High Court. All I'm saying is that the action of the claimants, which had been initiated earlier, with the latest being in year 2000, after the period which their cause of action crystallized, ran its full course of litigation from the High Court to the Court of Appeal, where the claimant appeal was allowed, and the matter ordered to be remitted back to the High Court of Kaduna State, which at the date of the decision of the Court of Appeal in the year 2020, no longer had jurisdiction, and which resulted in filing this action before this court. The above shows that the claimants were not late or tardy in bringing their action before this court. It needs to be emphasized that the object of limitation law is to penalize claimants who sleep or have unnecessarily delayed in the enforcement of their rights. In other words, the concept of statute of limitation is to allow a defendant take advantage of equitable defense of laches where a claimant is guilty of unreasonable and prejudicial delay in commencing a suit, which appears not to be the case here. The pendency of the previous case is filed by claimants at the High Court of Kaduna State in year 2000, and the culminating appeal at the Court of Appeal was obviously beyond the control of the claimant, as there was no way they could humanly control the time frame of the proceedings in those courts. The Court of Appeal allowed the appeal of the claimants, ordered that the matter be heard de novo at the trial court in year 2020. There's no doubt that as at when the above suit were filed before the Kaduna State High Court in the year 2000 to when ruling is Exhibit A6 was delivered in 2006, this court has not become a court of record in respect of labor matters. However, as the year 2020, when the Court of Appeal decided the appeal and ordered that the matter be reverted back to the trial court, being Kaduna State High Court, the court ceased to have jurisdiction over labor matters or payment and non-payment of entitlements of employees by the provision of Section 254C1K, which vested exclusive jurisdiction in such matters in this court. Little wonder the action could not be reassigned by the Kaduna State High Court, necessitating a filing before this court as the court of competent jurisdiction. Where in a situation such as this, the suit was commenced at the High Court of Kaduna State in year 2000, and due to no fault of the claimants, the case was at the Court of Appeal, ordered to be refiled, it would amount to grave injustice when the suit is refiled at the appropriate court, being this court, to allow the first defendant to plead limitation law. All I'm laboring to say here is that time froze from the time the suit commenced at the Kaduna State High Court in the year 2000 up to when it was decided by the Court of Appeal and ordered to be reverted back to the High Court of Kaduna State as the trial court in 2020. Assuming the case of a claimant is even founded on simple contract, the moment claimants commenced their early action at the Kaduna State High Court in the year 2000, by the two suits up till when hearing de novo was ordered by the Court of Appeal, time froze or is suspended. Time will only start counting after the order of hearing de novo was made in year 2000 to when the suit was filed in this court, being the appropriate court, with requisite jurisdiction over the claims of the claimant at the relevant date. Assuming the case of a claimant can even be said to be founded on simple contract in computing the limitation period, the claimant will still be within the ambit of a 6 years period of limitation as prescribed by Section 7(1) of the Limitation Act of FCT, since time froze and will only resume counting after the order of the retrial by the Court of Appeal in year 2020. All I'm saying is the right of action is still alive and cannot be lost or dead, and can be resuscitated by refiling of the claimant's case before the appropriate court, which is what claimants sought to achieve when they filed this suit in this court, being the court with the requisite jurisdiction to entertain this matter as at the said date. It is clear from the foregoing that no matter how one looks at it, the case of the claimants cannot be said to be statute barred by virtue of Section 7 of the Limitation Act of the FCT, as the defendant are contending due to the several intervening factors. In view of the foregoing, I am of the firm view that the claimant case is not caught by the statute of limitation of FCT. Question 1 is thus resolved in the affirmative and in favor of the claimant. Now to the merits of the case. I will have to skip this, please. I'll go straight to the concluding part. Everything is here. I will just go to the conclusion, and you will have copies of this judgment. You can obtain copies by tomorrow. I've typed everything, as you can see, but I want to skip it in view of time. So I'll go straight to the concluding part. For the avoidance of doubt and reasons earlier given, I declare an order as follows. 1. Claimants are entitled as employees of the first defendant to be paid the aggregate of their contribution in the Star Provident Fund under the scheme operated by the Nigerian Tobacco Company. 2. The purported terms of settlement in Exhibit A4 are set aside for not being a product of consensus addendum of the parties in this case. 3. The claims of the claimant in Release 4, 5, and 6 fail. 4. The first defendant is ordered to go through its record and, in conjunction with the claimants, calculate what the entitlement of each of the claimants is by virtue of what stands to the credit of each of them in the Star Provident Fund and pay them accordingly. And 5. The claimants are entitled to 1 million naira as cost of action against the defendants. Judgment is accordingly entered.
As the court pleases.
Very well. So like I
Thank
said,
my lord for the...
yes.
Well, I'm most grateful, my lord.
Very well. So you will obtain clean copies. You may send someone there tomorrow, next tomorrow, to pick up a clean copy.
As a couple, this is I'm most grateful. And we want to take this opportunity to sincerely congratulate my lord for your nomination and impending elevation to the Court of Appeal, my lord.
Thank you very much.
Thank you, my lord.
I wish you all the best.
Congratulations, my lord. It is exceptionally deserved, my lord.
Thank you. I wish you all the best. Was Olujoke right? Olujoke Aliu Esquire, right? Am I right?
Yes, my lord. Yes, my lord.
Olujoke Aliu,
yes, my lord. I'm online.
Yes, I love your your way of practice, your due diligence.
Thank you, my lord.
In handling your cases professionally. I'm getting to see Daphne Ugele for the first time, so I also wish you all the best.
Thank you, my lord. This is the second time, actually, but thank you, my lord.
Okay. Okay.
Thank you very much, my lord.
Very well. God be with you.
We look forward to seeing you at the Court of Appeal. Thank you, my lord.
Very well. Thank you. I rise.